Okay, hey, how you doing, everybody out there? Anybody that wants to follow along and pay attention to a particular case that's out there in the universe now, it's in Columbus, Ohio, for the comment, please. It's imperative that you know that there's an actual felony theft that took place. This here happened to me. Yeah, and it's currently going on um, right now. So I used to work at this place, CVS Health. I was an employee there. And CVS took over Aetna Resource LLC. I also used to work for Aetna as a contract employee. And I worked there for several years, like back to back to back in one particular department under one particular supervisor. Never had an issue, never had a complication, never had a problem. And in fact, it was contract role. So they weren't the employer. Yeah, she kept calling me back every single year to come to work there, and I never had an issue. They were the greatest people of all time. The company was the greatest company of all time, and that was the only reason, in fact, that I decided to take a permanent role with Aetna. But then I found out that it was CBS that took over Aetna, but didn't make me know. Never mind, right? But when I was hired on, it was a totally different department. It wasn't the same supervisor or anything like that, and that does matter. So it just was not a good fit for the people, the employees that the employer actually has working there. It's just not good. And the employer really needs to go back to the drawing board and find out what the true issue is. Because anytime your employees have you paying out money where you had to be vicariously liable for their actions, you need to go back and look at what those employees are doing. You should really do that. And they should probably be the ones that you fire and not the actual asset that did nothing whatsoever wrong. This was a wrongful termination. They say they did nothing wrong, but who am I to judge? The Ohio Department of Job. Okay, I had I had to run and see what that was. That's a damn washer. I think it's a daggone washer because it was so freaking loud and stuff like that. Sounded like somebody fell. One of my sons used to have seizures, and he could sit and be talking to you and just fall out, bust his head, stuff like that. And when I opened up the door, I think it's actually the washer. I don't hear anything right now. I went in, there was a washer going. I was like, wait. So anyhow, I got distracted real quick. Yeah, I actually thought that was somebody falling down the stairs. Oh, that's scary. So anyhow, this just a conversation. Doesn't matter. This ain't structured. This ain't no real, curriculum that I set up or nothing like that. This is my real life, and this really did happen. And everything I say is true and accurate. And no one will ever in life be able to refute or rebut anything that I say. And also, because I have receipts to back up everything that I say as well. And that's what people don't like. Yeah, they don't like people like me, yeah, who ask very clarifying questions and stuff like that. And, just to get to the bottom of what's really going on, especially when I, at the end of the day, can be held accountable for something. Again, I have a whole nursing license, and I'll never put that on the line, not for anybody and not for a job, not for an individual, not for shit ever. And neither should you if you have a license or something like that. No, you should not. And that's nursing 101. You better never do it. You will be tested. You will be tested. And there are no real safety that's for you. There really is no agency or entity or anybody that you can go to that's really going to stand up for you, defend you, speak up for you. Nothing else. Nobody, nowhere is nobody. Okay. But I'm gonna keep on bringing you awareness and things like that, and then hopefully, if you're ever faced with a situation like this, hopefully this particular instance in this case and the things that I talk about will hopefully one day result in some change. And then if you are ever faced with it or somebody that you love and care for, is faced with it, there'll be something out there where, you know, it serves as a win, to where people will think twice before they go violating your rights and stealing your money and just doing whatever when you've done nothing wrong ever to anybody. Like, and I don't have any bad performance reviews. I don't have anything. I just go to work, try to help my patients, and just do what I'm supposed to do, and that's just it. But if you speak up and you speak out and ask questions about things that aren't right, they're unethical and illegal and stuff like that, you go against the grain of whatever wrongdoers might be doing. And if that's routine for them, they don't like you and they will retaliate against you. So don't believe one red cent of any fucking thing that anybody says that, oh, they're not allowed to retaliate. No, they can't. Well, yeah, they're not supposed to, but they do. Okay. And it's swept under the rug and they get away with it. For even the oversight agencies that have the awareness of it, they allow it. They know about it, they allow it, and they just will try to silence you and shit like that. Mm-hmm. But in this particular case, Aetna Resources LLC, they must have wanted you to know. They must have wanted you to know during the universe and the public, because they went and they filed something in the court. That's a public forum. You put it in the court, so you must want it to be known. All right. And so if you started it, I can't just sit back and not tell my side. I have to be able to tell my side. That's only fair. I have to be able to tell my side. All right. And still, I haven't told it all either. Okay. So, but I'm going to end up telling it all real soon. All right. So these people at the Resources LLC, along with their attorneys, Richard Diageo and Alex Frondor, they devised a plan of how they could steal my property of $15,028. They owed me a lot more than that. They paid everything but $15,028. Okay. There's a general release that exists, and there's an EEOC MSA agreement that exists. They breached both. Okay. So what the agreement says, both of them say the exact same thing as far as what the disbursement of the funds is. If they both say in total, an entire sum, every single dime that's owed to me post a wrongful termination, and the Ohio Department of Job and Family Services, you know, unemployment, they're the ones that determined that the termination was wrongful. They said that I lost my job by no cause of my own. All right. Okay. Yeah, so they gave me unemployment benefits. You do not get unemployment benefits if you cause your own termination, because it's an at-will state anyways. So they're not going to give you unemployment, because a job can fire you for whatever reason that they want to fire you for. It doesn't mean you're going to get unemployment. Okay, so they said that I violated some type of policy. Well, unemployment asked them to prove that, and they were unable to do that. All right. So they said, unemployment said, well, no, we're going to give her money. So it sounds like wrongful termination to me, but now that Aetna put it in the court for you, you can go ahead and make that determination decision on your own. Okay. We came to a mutual agreement that the shit was going to be over and done with, but Aetna forced litigation on me, knowing that they snatched away my livelihood. I don't have a job. It's very difficult to even find a job now. Yeah. And they continue to retaliate against me. Yep, the EEOC has the complete and full awareness as well of a breach of their own MSA. Thomas Cocklaw, Jamie Williamson. Thomas Cocklaw is out in DC. Jamie Williamson is in Philadelphia. Dilip Gakia and Anissa Perez, the Cleveland field office. Everybody knows. Everybody keeps making up lies and spinning the narrative and telling half truths and all that to cover other people's asses and all this type of stuff. And all at the end of the day, I continue to be victimized and severely harmed by all these poor behaviors of these individuals that fail to just go ahead and take responsibility and be held accountable for their own actions and shit like that. And you know, EEOC really is supposed to protect the employees, advocate for the employee. Now, why won't they enforce their EEOC MSA agreement that's been breached? They will for some. For some, you see it always on the news and stuff like that, or in the social media, you see that they will enforce their settlement agreements for some, but not for me for some reason. Sounds like discrimination. Sounds like it's something discriminatory. Why won't you? Well, what they told me in a letter on February 1st, Thomas Cocklaw, he has somebody named Wesley, I don't know the last name, sent a letter on February 1st of 2023, stating that the reason why they don't see that it's a breach is because Aetna placed the money in a court. And because they placed it in the court, it's out of their hands and they no longer have control over the funds. Well, that's not true. And Thomas Cocklaw and EEOC actually know it's not true. There is no money in the court. My $15,028 is not in any court registry. It's not in a trust account. Okay. And it's actually not with an innocent third party that doesn't have interest or ownership in the funds either. All right. Which those are components of an interpleader. Okay. This is a fake interpleader pleading. And it's only Alex Frondorf's way of trying to mask the unethical behaviors of Richard Diageo, of the behaviors that Richard Diageo participated in and spearheaded during the EEOC mediation, which occurred October 14th of 2022. The settlement agreement was signed October the 18th of 2022. All right, so yeah, basically Richard Diageo and the EEOC mediator, Salvador Lopez, yeah, they were accused of trying to trick me into signing an agreement that actually allocated $15,000 to Spitz Law Firm. And yeah, I said, I'm not going to agree to any type of settlement whatsoever if you have that language in it. So of their own free will, both of them, Richard Diageo, after I said that, he said, I understand your position. I have that in an email from Richard Diageo to me, where he said, I understand your position. After I said, trying to trick somebody, that this is what Spitz did. He said, I understand your position. I will go and take out all the specific language in that agreement. So he voided that first agreement because he ran over there and he told Spitz Law Firm he had $15,000 for him because he wrote it up like that in that agreement. But he never went back. He neglected to go back and tell them that he actually voided that agreement because of being accused of duress to sign and trickery and deceit. He never went back and told them that. So that's what this is stemming from, the fact that he never went back and told them that. So they were anticipating that they had a $15,000 check coming to them, okay? But then later he sent them an email saying, oh, CVS is going to send $15,028 to April Clark. Okay, as it's technically a part of the overall MSA settlement agreement, right? And it's owed to her an entire sum. So he knows, but he's faking the court. So he never told the court that, right? I had to go and tell him, right? Yeah. So, and then Trisha Breedlove over at Spitz Law Firm sent him a message back, like, excuse me, what you talking about? Because he never went back and said he not sending the 15,000. So then instead of telling her, oh, I voided that because of XYZ, he told her, oh, she repudiated that particular agreement. Well, no, actually, he voided it, which ultimately is a repudiation, but he is the one who voided it, okay, for specific reasons. And then he rewrote it, took out all that specific language, allocated 15,000, 15,028, or any amount of money to Spitz Law Firm of my equitable property. Okay, so every single dime, all of it, of the entire total settlement agreement amount should have been sent to me directly, as stated in both of those agreements. Okay, but it was not, because Spitz Law Firm, Trisha Breedlove, they threatened Richard. They said, no, we know what you told us. And you asked us for our W-9. You told us we had that coming. Now, what has happened here now? We don't understand. There's something going on now. We're going to sue you individually for your personal assets, and we're going to sue Alex Frondorf, your colleague, for his personal assets, and then we're going to sue your damn firm, Littner Mendelson PC, for the shit too. You sitting up here playing around and lying and stuff. But Richard actually is playing both sides of the fence instead of just owning up and saying what he did and taking responsibility. I mean, if he gonna have to pay, he gonna have to pay. He got a whole law firm and shit like that, but cut him with that $15,000 check if you did what you did. But instead of doing that, they said, well, let's keep on abusing this girl. Get on board with all the retaliation. She don't have no job. She don't have shit. She don't have a pot to piss in. So let's go ahead and just keep retaliating and abusing her. EEOC ain't gonna protect her. They know all about it too. They know that their very own EEOC mediator, Salvador Lopez, also said, I'm sorry, I didn't try to trick you. Sent an email from him too. It was just a miscommunication. I won't gain anything from tricking you. You can talk to my coordinator if you want, but I'll make sure I void it out. Then he sent the email to all parties involved. Richard Diageo, Karen Gaster, who's another attorney for Aetna, myself, and anybody that was on board with that thread, saying, listen, in light of what has happened, Ms. Clark says she's not going to sign an agreement at all to settle if you do not take out the language paying Spitz Law from any of her money. So that is what we did. We took out all the specific language and, hopefully we'll be able to come to an agreement. So both of them took out the language. Richard Diageo sent me an email saying, listen, as you requested, all the specific language allocating Spitz 15,028 is taken out. I just put in there that I acknowledge that a fee dispute actually exists between you guys. But yeah, I went on, took that out. He sent me his redline.doc, which is a Word document draft. He told me to read it. and make sure it was okay, then give him the go-ahead to finalize. All right, now this is the absolute truth, and I have all the evidence. Okay, but they're covering it up. So we got to let the public know. We got to put it on the record and everything like that. It's a lot of bullshit. It's a lot of corruption. Lots of people in cahoots. Okay. My suggestion is that in anything like this, in Columbus, Ohio, especially dealing with the court of common pleas, you request that you do a demand for jury trial because it's a lot of cahoot type shit going on out down there. Yeah, like Judge Karen Phipps, she revoked my rights to deprivation under of rights under color of law and common pleas 22CV 003620. She went to school with the lawyer Michael Casone and all this type of stuff during the same 10-year Capital University Law School. And maybe that's where her bias came from. I really don't know. Maybe she doesn't like people who are pro se coming up into the court. I really don't know. But she actually was unable to be impartial. She actually was biased. She was prejudiced. The Ohio Supreme Court Disciplinary Board has awareness of every single one of these attorneys that I'm talking to you about and what is going on, and they're not doing shit. They know about Judge Karen Phipps and deprivation of rights. She violated USC Title 18. If she did, she's been turned into the Department of Justice, everything like that as well. That's a crime. She should not be on the bench. She revoked my entire right, my liberty, my civil, my human, and constitutional right. I should be able to bring a case as a plaintiff where I've been harmed severely and get remedy, right? So she didn't even give me back my security deposit from the slumlord and the property management. Yeah, where her buddy pal friend Michael Casone, who went to Capital University Law School with her during the same time frame, they want to play and act like they don't have a professional or personal relationship and just fucking around and stuff like that. Yeah, so yeah, she had the knowledge that in 21CV020711 at Franklin County Municipal Court, that particular case was reopened and reheard by Judge James Green. He sat in there. It was me and my daughter. It was my cousin, a guy named Rob Grabach of Alcania. We all sat in there together, and Judge Green asked very pointed questions about that agreement that Karen Phipps ended up putting in her ruling on her harsh summary judgment for her friend Michael Casone, actually Alex Castle, because Michael Casone, the property management, All County Neo, that's actually his very own personal real estate property management. He utilizes them. He's the owner and he rents out properties, and that's the property management. That's why he goes so hard for them. And he wanted me to go ahead and let the insurance company know that retract a true report of fraud where the property owner at 2951 Hubbardton Place, Middleburg, Ohio 43068, was actually submitting false claims and putting false incident dates, like saying, oh, that started August the 7th, when really he knows and knew all of the pre-existing conditions of the place when he bought it. He misrepresented and rented it knowing that it was not habitable. It was unsafe. We almost blew up in there, just like the recent case. Yeah, they had to come and shut off the water heater. Yeah, because the gas was, it's fed by a gas line. And it was actually rolling flames on top of it. So improper combustion can cause the entire place to blow up in the whole block and everything like that. So we almost died. But luckily, Columbia Gas, we smelled gas. So thank you, Jesus, right? So luckily, Columbia Gas evacuated us, came out, they red tagged it. They said, oh, we can't turn this on until they get it fixed. Yeah, but nobody cares about that, right? So it's 29 public records on that particular address. You can look up 2951 Hubbardton Place, Reynoldsburg, Ohio 43068 with the city of Columbus, 311.gov. All right. And also, or you can look up their individual names. Krishna Quadatata is the property owner, and All County Neo Portfolio Property Management. They were the property management that came on board in September 2020, which was after the tenant, which is myself, had paid the entire lease contractual agreement already in full before they came on board. Yeah, they never seen the place. They never did a walkthrough. They never, nothing. They didn't never see the place until we moved out. They didn't know anything about him already having this was for my grandbaby. I don't know. They didn't know that he had already been reported to the city before when COVID prevented in-home inspections. He had a sunken laundry room floor in there that he was supposed to fix. That's what he lied to insurance about, saying it started August the 7th. He said, please don't tell them that it's been going on for a continuous time or they won't cover the cost. He knew exactly what he was doing. He was an Indian man out there playing like he don't know the language and shit like that, and acting stupid and stuff. And he damn sure know how to fraud. He damn sure know how to write real good in English. And I got all the texts. Michael Casone sat up here and sent me a threatening letter and tried to coerce me. He said, or if I don't do it, then he's gonna set me out on the street and stuff like that. Okay. Yeah, no, that's not good. So Karen Phipps wanted to cover up the fraud for her buddy pal. Then Michael Casone, he gave the case, the common pleas case 22CB3620 over to Alex Castle. So it wouldn't look like anything conflict of interest. So he could be like, if the public or anybody questioned, like, well, that's why I gave Alex the case, because this is my property management and everything like that's why I gave him the case. And the Supreme Court already has the awareness of that conflict of interest or whatever. I mean, I guess you could defend your friends and stuff like that, but when you go to threatening people and things like that, I mean, it kind of looks bad, doesn't it? Yeah, he's a bad apple attorney. And what Karen Phipps did was try to silence me. And she also knew that this was a hands down win case related to severe landlord retaliation. Yeah, and actually had the case went through, and she would have really been impartial, and she really, looked at the matter from a third party perspective and gave a true opinion in accordance with what the law says. It would have been a great landmark case for a win for tenants all over the world to utilize as their own case law when they were fighting against, cases where they were retaliated against post their exercise of their right to complain to a government agency regarding conditioned dwellings and not be retaliated against. So if a landlord actually retaliates against you, then you would have that case law, and then you would be able to look at the opinion of that and know that you would be okay if you did exactly what you were supposed to do, right? As a tenant. Yeah, so they covered that up. Yeah, dismiss without prejudice actually does mean that you can, it means that your case was not adjudicated on the merit. It means that you actually can refile it in the court of jurisdiction, right? And because of the prayer amount, that is why it was filed in common pleas, okay? Because the lower tier court, Franklin County Municipal Court, it's capped off, and we wanted more money off of that because we were being stalked and harassed and intimidated. Absolutely. And had to live in those types of conditions. And we had paid all of our rent and all of that. And that landlord did not uphold his end of the bargain, his obligations. It was very negligent. So was his property management. And then the property management had the nerve, audacity, and gall to go file a retaliatory eviction. And they couldn't speak to the totality of the circumstances. They were not on board. They don't know the pre-existing condition of the place. They've never seen it because they weren't there. We signed the lease back in May of 2020. Okay, all that rent had been paid by October of 2020. Okay, in full in 2 lump sums before they even came on board. They had no clue of what was going on. So who the fuck do they think they are going to sit up here and just jump on in and start retaliating against somebody when it's their client who he failed to ever tell them he already had complaints on him down there with the city of Columbus. But everybody knows that the city of Columbus knew it. Tierra Ross, she was his own prosecutor at that time and everything. I talked about this already on another video. Right, it's corruption down there at Court of Common Pleas, okay? And everybody in the world has the awareness of it. So the U.S. Inspector Generals, the Ohio Inspector Generals, the Department of Justice, everybody, all this shit that's going on, they have the awareness. They know that Karen Phipps revoked my rights, okay? I mean, all they had to really do was allow me to have my day in court, and then Judge James Brinkley came and spoke to the ruling that he gave. So that case was actually reopened at Franklin County Court of Common Pleas, 21 CV 020711. Yeah, after they had the awareness of everything that was going on, that there was an actual environmental case against the landlord property management based on all of the complaints. Those 29 complaints and outcries for help, and then there was code violations that they deliberately intentionally ignored. So the city brought a case against them because they were ignoring the order to fix the shit, right? But the city's never going to do anything anyways. They're not going to enforce anything. They know you're going to be so severely retaliated against. You're either going to move or they're going to end up getting kicked out. It's going to be some bullshit. They're going to shut the water off on you. They're going to do all this shit. They shut the water off on us and everything. But the whole nonverbal autistic baby in the household too. Yeah. So where's the outrage? Nobody cares. And there ain't even no citizens out there that really are outraged or mad about that or speaking up, speaking out and saying, oh my God, how could you do that to a family that paid all their rent and everything? Y'all almost killed them and all this. Nobody's speaking up, nobody's saying anything about it. Okay. But we need to make sure it's out here in the public so that there can be public scrutiny. And then just so you'll have the awareness, I mean, whether nobody stands up for us or not, it doesn't matter. We're going to continue to stand up for you and ensure that you have some things that you can go to in the event that any of these things that we talk about happen to you, okay? And maybe through this, you'll get some awareness and learn to develop some strategies of your own and how to fight back. It would behoove you to demand a jury trial if you're in Columbus, Ohio, dealing with these attorneys and judges that are all in cahoots together and shit like that. Yeah, and that will minimize, you being treated unfairly. Just let a jury of your peers determine what's going on and, determine what it is for you impartially, okay? And then allow for that public scrutiny, okay? And then maybe people will begin to get their shit together, right, so anyhow, this is in the court of common pleas right now. Currently, you might want to pay attention. They scheduled a hearing for sometime in November. I think it's November the 2nd. This, which will be a whole year, damn near a whole year since Alex Frondorf. He went and he filed this case. November the 19th, I believe it is, or something like that, or 9th or something of 2022. Yeah, he took the risk of going ahead and filing this fake claim is frivolous in the court. So it's fraud in the court. It's a whole lie. It's half truths. Okay? So they're pretending that they're just a mere insurance company. They don't have no clue. They don't know shit about it. They don't know that all of a sudden, like, they know that they owe $15,028 to me. They know that, and they're willing to pay it and everything. But like all of a sudden, then they found out that Spitz is claiming that it's owed to them. Spitz is claiming it's owed to them. There's no lien. There's no court order. There's no judgment on my $15,028. Aetna Resources LLC, CVS Health was to pay me all my money directly, point blank, period. I don't have my money in my hand. So they seized it. They seized it. They gained control over it without consent. You're not allowed to do that. Okay, so they took my money without my consent because somebody just came out the blue and said it's theirs. Okay, so I guess you could have just went and called Richard Diageo, one of them, and say, hey, that's my $15,000, and without getting any type of proof or backup or nothing like that of an existing lien or a court order or judgment, they just can steal it. Say, oh, okay then, okay, it's yours. Okay, we'll put an interpleader in. That's not how it works. You can't do that. There's no lien. There's no judgment. There's no court order. So there's no right for you to take my money. I never did consent. You have to ask for consent. And that's what they did. So Richard Diageo sent me an email and he asked me, would you consent to me holding onto your property for XYZ, because of this? They know that they have to ask for consent because it's against the law if you don't. It's theft if you don't. So yeah, he sent the email asking for consent. And I said, no, you send me my money just like how you agreed to. Okay. But because Fitz Law Firm Trisha Breedlove told him that we're going to sue you individually, you and your colleague, they have to protect themselves and their own assets. I mean, they're going to do it by all means, and they don't give no fucks about me. They're just going to steal my money. They're going to fake and devise a plan to put use the legal process to put an interpleader in the court and make a mask to the court that it's a true interpleader. It's not, it's actually theft. And because of the amount, it's felony theft. So he tried to get consent. He didn't think I was going to say no. But because I didn't consent, they had to get together and figure out, well, what other way can we get the money and shit like that. Well, we know she ain't gonna be able to fight it in court because she's broke. We took her job. She don't have no money. She don't have nothing. She's not smart. She's stupid as fuck. She's just a nurse. She doesn't know anything. Nobody's gonna take this case because legal aid doesn't take complex cases like this or anything like that. So no attorney in Ohio is going to take her case. We're all butt fucking each other and shit like that. Anyway, we're gonna make sure we let them all know not to take her case and shit like that. So yeah, let's go ahead and do it. Yep, and then that one will be cool because she won't get her own money anyways. It'll probably go over to Spitz and it would be free and clear and they won't sue us and shit like that. Yep, but yeah, they thought I was a dummy, but I'm far from that, okay? And yeah, so basically this is what happened, okay? Now comes defendant April Clark to inform this court that the theft of property in the amount of $15,028 has been reported to law enforcement. It's all true. Okay, and this instant and associated cases, all right, 22CV008947, that's me suing Spitz Law Firm for malpractice. Okay, and 22CV008936, that's me suing Aetna Resources LLC again. All right, and I'm going to bring back all the other employment cases all over again. But what I'm thinking about doing is getting ready just to go ahead and sue Richard Diageo individually, Alex Frondorf individually, Karen Gaster individually, in federal court, for what they did. Yeah, yeah, criminal. They stole my money. They did it on purpose. So yeah, so I said there's likely an investigation. So 22CV007866, and the court was filed by Alex Frondorf, and he works for Littner Mendelsohn PC. November 19, 2022, and no ruling on several of the pending motions has taken place to date, July 12th, 2023. I didn't mean that needed to come out of there. September. What I meant to put in there, but anyhow. And I meant to put September. I need to amend that. It doesn't fucking matter, honestly. They can see no rulings been put on the bitch. I put the first letter into the court with that date, and they keep ignoring it. So basically, they filed this case, and there's a judge on it called, his name is Chris Brown. He hasn't ruled on any motion, any pleading whatsoever. My money is not in any trust account. It's not in any court registry, and it's not with an innocent third party that has no interest or ownership in it, where it should be gaining interest. $15,028. It's not anywhere like that. It's corruption. This is theft, and they're trying to cover it up. That's what they do, and that's why these attorneys file these cases locally. They like it to stay at the state court because they have all these networks of friends and buddies and stuff like that that they're socializing with behind the scenes and shit like that, and they're scratching each other's backs and shit like that. When it's really not okay. Like, I did not do anything wrong. Why did y'all steal my money? Like, it's ridiculous. Like, first of all, you took my fucking job. I agreed for pennies for you to pay me. Then we're supposed to part ways. But you're still fucking with me and bothering me and shit like that. You didn't pay me with all my shit. So you could be out of my hair. Here I am still being bothered by Aetna Resources and CVS behind the shit that their employees did. Okay, now they got the whole company harassing me. So not only now that your employees bothered me while I was on the fucking job, that led to all the complaints, that led to the balance of the OSHA whistleblower, that led to the balance, just an OSHA claim, then an OSHA whistleblower, then the EEOC, then a House Civil Rights charge, then the EEOC, then a federal case, okay? 2:22022519, U.S. District Court Southern Division. All right, that's the federal case. I participated in protected activities, and immediately following me participating in protected activities, within less than 3 to 4 weeks, I was fired. They immediately initiated, what we all know that jobs do. They start to make it seem like it's a performance issue, a performance problem brewing and stuff like that. And they start making up shit, making up lies, and trying to find any way to get you out. So that's basically what they did. But they could not validate anything. It's all lies. And I document everything. I have receipts on everything. I have everything. I even have something that I haven't told the public yet that they did, that they actually sent over in their employer statement to the OSHA investigator. And I'm getting ready to tell that pretty soon too. Yep. Yeah. So it's a whole lot of lies, a whole lot of trickery, a whole lot of deceit and shit like that. Okay. So they breached that agreement. So I mean, all bets are fucking off, I guess, right? So I gotta come out here and tell my side of the story. All right. So yeah, and the court really doesn't give two fucks about any settlement amount being confidential. I'm actually being nice by not telling the total settlement amount. It ain't shit. Nickels and dimes. It's not, it's not shit. These motherfuckers need to pay me more than that. Every single one of these people that are participating, this is a whole wrongdoing. Well, where's the outcry? Ain't nobody saying shit about it though. This actual theft. I damn sure hope it don't happen to nobody else, because the only time people ever care about anything is when it happens to them. And this can't happen to you. And I'm sure it has happened to other people. They just didn't speak out about it and stuff like that. Because this is what I find a routine with these people. They utilize their legal expertise and legalese and stuff like that. And they take a legal process and everything like that. And they spin the narrative. All right. And they spin it in such a way that it meets their own objective and their own agenda. Yeah. But, and it looks good on the surface to a lay person or whatever. But, oh, yeah, no, attach case law and everything else to it. But they leave key pertinent information out, and they do that deliberately and on purpose, just like Karen Phipps did. She only told up to a certain point of what occurred in the lower tier court, Franklin County, with the school court. She only told what happened up to the signing of that agreement that actually was signed under duress, because her buddy Pow Michael So placed the tenants under duress to sign that. Yeah, he was coercing and threatening. So we have to let the court know that. We have to send in something to Franklin County Court of Common Pleas, give all the details, and then put in also like a declaration that had to be sworn in. You send that in. And so the court itself reopened up to 1CV020711, and they set it for the hearing in front of an actual judge. Okay, now Karen Phipps didn't put that in her summary judgment, though, did she? Of course not. But she knew it. She knew it, but she didn't put that in there. Yeah. And then, yeah, she wants to strike everything that we put in there so that the public never knows. That's what they did. But a true investigation will be really off. So she needs to be arrested. Yeah, she actually did break the law. She deprived us of our rights. When somebody like that is in a power and they can actually revoke your human right, like your innate right, that's not good. It's all over for you. Then what else do you have? You don't have shit. You can just be abused. And you don't have no recourse, you don't have shit. And that's not how it's supposed to work out here. You have due process. You have a right to bring a case against somebody that harmed you and not have somebody being on their side. Yeah, no, she did that. She's a whole piece of shit. And don't you vote for her in 2025. Don't you do it and go tell the entire world that she broke the law. USC, yes. Title 18, deprivation of rights under color law. Yes, she did. Just go call and ask Judge Green. Did you rehear this case? Why did you rehear it? Did you dismiss it without prejudice? Did you sit there and tell everybody that was in attendance at in your courtroom, Judge Green, that did you tell the tenants? Oh, you don't want to hear it here because of the jurisdictional limit that's in this court. All right, well, go refile it over there in common pleas then. Michael Fasone heard it. Rob Rivak of All County Veto portfolio heard it. The tenants heard it. Judge Green said it. So what was Karen Phipps' problem? Did she have a complication and issue with that type of ruling coming from a black judge or something like that? Karen going wild? She thinks she got some white privilege or something like that. She can just do whatever the fuck she want to do. She's gonna overrule what Judge James Green said down there in Franklin County Municipal Court. You don't know what dismiss without prejudice means? Capital University Law School, what type of product do you have coming out of there? Huh? What's the licensing board gonna do about it? Huh? Columbus Bar, you gonna do any fucking thing about it? Huh? Who gonna get this damn judge off the bench? ACLU, where you at? She depriving rights. Huh? Hello? What? Department of Justice? Excuse me? Yeah, so this is all true. It's not a lie. Okay? It's not slander, it's not libel, it's not defamation. It is absolutely true. So she committed a crime. That's a crime. Yeah. Okay. All right. So it's severe retaliation. So the cases that are all linked together in that Franklin County Court of Common Pleas cases 22 CP003620. That's deprivation of rights under the color of law. Karen Phipps did that crime. Michael Casone, bad apple attorney. Alex Castle is also a bad apple attorney. He had audacity and nerve and gall to write in his brief that the lower tier court, Franklin County Municipal Court, they put a journal entry. Must be a journal entry for dismissal without prejudice. Who does he think he is? If you question it, let the shit go to trial so that Judge James Green can be called in. Okay? Yeah. Go ahead and let it be, let him speak for himself. They didn't want that. They didn't want anybody to be called in. They didn't want Attorney Tierra Ross to be called in to ask, why didn't you bring the retaliation case that you actually put on hold? Okay, so the city of Columbus gave those the retaliation paperwork and all of that, but she never brought the case. But right now, today, the city of Columbus is actually acting as if housing initiatives have passed that include landlord retaliation protections. But that ordinance is actually unconstitutional. It's been found unconstitutional already. That's the reason why Tierra Ross claimed that she put the retaliation case in this instance with 22 CV 3620, common pleas, Franklin County Municipal Court 21 CV 020711, and Franklin County Municipal Court EBH 060439. They're all linked. It's all a whole story. All these cases, common pleas, and the Franklin County tells the entire story. Okay, the 29 public records down there with the city tells the story. Yeah, so Tierra Ross says she put it on hold because it was actually the ordinance was being challenged in environmental court right there. But once she got the green light from the court, then she would bring the case, retaliation case. Well, she never got the green light because the court found that the ordinance itself was unconstitutional. Okay, they never went back to the drawing board, as far as we know, because Tierra Ross told the Ohio Supreme Court Disciplinary Board that she was working with City Council at that particular time on developing a new ordinance. Yeah, and so the Ohio Supreme Court Disciplinary Board sent us a letter saying like, well, so once you know, that is done, once that ordinance is in place and it's constitutional, then if the statute of limitations hasn't run out for you to bring a retaliation case, then the city can consider bringing a retaliation case. She's no longer his own prosecutor, but you know, she's a city attorney now or something like that. It's all true. It's all fact. Yeah. So it's on social media, but they never speak to it because they don't really want the public to know what they've been up to. Okay. These public elected officials, you need to pay attention to and what they're doing. Remember this for the next time that you're electing them in office. It's a lot of underhanded shit. So they swept that severe retaliation case under the rug. We were actually very severely harmed and victimized. Yeah, we were. Yep, but nobody did anything about it. So that's Krishna Quadatada. He's an owner. And also, I had my neighbors over there. They lived at 2949 Hubbardton. Their place was fucked up too. Yeah, I had them on the witness disclosure list. They came in, they could have testified to everything. Yeah, they could have. Krishna Quadatada, he could have came in and testified himself as well. Anybody could have been called. Oh yeah, neighbors could have been called. Judge James Green himself could have been called. Said, did you put dismissed without prejudice, or was it a journal entry like Alex Castle just said an error in the journal entry? Like, who the fuck Alex Castle think he is? These are bad attorneys. So we're trying to figure out when is the Ohio Bar Association, Columbus Bar Association, or any bar association going to revoke their licenses. The Ohio Supreme Court disciplinary board, they have grievances on them. They're not investigating. They don't do comprehensive investigations. They never have called my telephone, not once, to ask any interview questions, any branching questions, ask for any evidence. Now, they'll send you through your email like something like whatever that attorney may have said, and you can send a rebuttal, you can send it in, but they don't follow up. They don't do any fucking thing. What's his name? Michael Casone got about 3 on him because they keep on acting like they can investigate it when the case is open. Now the case is closed, so get to investigating. Investigate Casone in 22 CV 3620 21 CV 020711 EVH 060439. He's the attorney on every single one of them. Alex Castle was not the attorney on the environmental court case in Franklin County Municipal Court, and he damn sure wasn't in the retaliatory eviction case in Franklin County Municipal Court either. He doesn't have any firsthand knowledge of shit. He wasn't in the room with the judge. He didn't hear what was being said. He didn't hear shit. Okay, but he went over there trying to fight the case at common pleas, acting like he knew. So I don't know if Michael Casone didn't tell him that he was threatening people doing all this and what exactly happened. But the case was reopened at the lower tier, okay, Franklin County Municipal Court. The retaliatory eviction, it was reopened 2-1 CV 020711. James Judge Green. He sat up there on that bitch, he heard it. Michael Casone heard everything he said. He asked Michael Casone, so do you have a case against the tenants over here? We were already moved out. So do you have a case against the tenants? Do you have any damages or anything like that? And they said no. So they should have immediately paid the security deposit out. And they did not. So we could have got our security deposit back even at very minimum over in the 22 CV 3620 Judge Karen Gone Wild Phibbs case, where she deprived the tenants, the plaintiffs, of their right, of their liberty, okay? Their civil, human, and constitutional rights under the color of law, okay? Which is a crime, USC, Title 18. Yep, she's a criminal. She's a suspect. Where's her picture? Why isn't it plastered all over the fucking place and shit like that? Why isn't Richard Diageo and Alex Frondor's picture plastered all over? They're criminals. They stole $15,028 from somebody. It's damn near like they went in my damn purse and took out $15,028 out of my purse. When they first asked, could they have it? It's just like you going and asking your mother, can I have $5? And she tell you no, and you go in her purse any fucking way, and you gain control. You seize the $5 when she fucking told you no. She did not consent to you getting $5 of her fucking money. You go in the purse anyway, and you take it. It's theft. It's $5. It's petty theft. This $15,028. This felony theft. All right. So we need to get to seeing them on plastered all over and going to jail. Yes, we do. Just like anybody else. Ain't nobody above the law. Ain't nobody above the law. It's time to go to jail. Who about to pay me my money? That's what I want to know. And who gonna put some punitive damages or something like that on all these people that's involved in this and get to paying me right now? I'm suffering. I'm a victim. Okay. Yeah. So I suffered. I'm a victim from the shit that Karen Phipps did in 22 CV 3620. Franklin County Court of Common Pleas. She's a criminal. She needs to be in jail. And who gonna compensate? Okay. I'm a victim of a crime. I'm a victim of a crime. All right. Same thing in this case. Court of Common Pleas. You see the commonality? The Court of Common Pleas. There's corruption down there. It's bias, it's prejudice. They're scratching each other's back. They're in cahoots and all that shit. Demand a jury trial in anything that you do at that court. All right. Chris Brown is presiding over this particular case. It's 2 cases now because they're consolidated. So he's presiding over 22CV007866, and he's presiding over 22CV008947. Michael Holbrook is presiding over the case that I actually filed against Aetna. And that particular case is a direct result of this case that Aetna filed against me. Okay, 22CV008936 is Michael Holbrook. All right, he hasn't made any decisions on that. Nothing's been done on that, or whatever, because maybe he's waiting to see what the fuck's going on with this. I mean, I really don't know. But at the end of the day, all these people owe me. They've been victimizing me, and my family and shit like that is suffering severely, and nobody's doing shit about it. EEOC, all of them need to. Everybody needs to pay me. They're not protecting. They're not doing anything. They're not a true advocate at all. They're discriminating against me by not wanting to enforce my MSA EEOC agreement, but they will go and enforce somebody else's. They'll go enforce theirs if the employer doesn't uphold their end of the bargain, but they won't do mine. Why won't you EEOC? Is because I'm Black? Yeah, I think EEOC is discriminating against me based on my race, my creed, my nationality, my disability. I do have disability. And I think they're retaliating against me as well, because I brought it to the world's attention in the public, and I let the Senator Claire Brown know. I let Congresswoman Joyce Beatty know about all of this, and the EEOC and the EEOC mediator, and Thomas Copplaw, and Dilip Gakel, and Anissa Perella, Sabrina Austin, that's the federal investigator. The EEOC charge number is 532-2022-02705. Dilip Gakel and Anissa Perella gave me a call in January. They said, okay, since we see what's happening where they filed this in the court on you and everything like that, and they didn't pay you the $15,000 like we know that they're supposed to pay you, go ahead and file a new retaliation charge in the portal. If you don't know how to do that, we'll show you. I have it all in writing. It's actually an email form. Yeah, Dilip Gakel, he sent me an email about it. So if anybody ever want any proof, I got it. I've already given every single piece of documentation that I have to everybody anyway. So Congresswoman Joyce Beatty's office has it. I uploaded every single thing to them. Sherrod Brown's office has it. I uploaded everything to them. Sherrod Brown's office is very, very, very good. The EEOC portal itself has it in there. I uploaded every single thing in there, all the emails, everything, proof of everything. So the new retaliation charge is 473-2023-007711. And Sabrina Austin was the person who was supposed to be investigating that. She had to be told twice to fix the portal to where she put the recommended changes in. She was trying not to put in what I had to tell about the whole story because it named the EEOC mediator and what was going on with the trickery and deceit and coercion and duress and stuff like that. So she tried not to put it in there. So I had to copy it and put it in an email to her and say, please put this in there so that the world can know, because their emails and all that's public record. It could be cool, right? It's discoverable. So that's when she went on and put it over there, but she didn't want to. She told me that her director, Dilip Gakel, had already told her what happened. Okay, so that's all second person. And then Dilip Gakel, whatever the fuck he told you, he'd tell you right. And then she told me what he told her. And she had it all fucked up, misconstrued, shit like that, because that's how the shit happens. Now, bitch, you want to know what happened? You ask me. First person. Okay, the shit happened to me. I know what the fuck happened. I'm the one that put the shit in the portal. You don't write shit for me, bitch. Okay, Sabrina, bitch, you kiss my ass. Okay, all these motherfuckers need exposed. Now, who gonna pay me? Who gonna pay me for my wrong? And just know that ain't no telling how many other motherfuckers out here this shit gonna happen to. Okay, and I'll never stop. I'll never stop. I'm gonna put on every single platform that I can get my hands on. I'm gonna let it be known this is wrongdoings. EEOC is discriminating against me too because I'm Black. Because I'm Black. All right, because of my nationality, because of my disability, and because I let all these people know out here what's going on, that could be potential oversight for them. What they did, they retaliated. So who's over them? They're retaliating, they're discriminating against me and everything. Who's over them? Who could I file a charge against them with? That's what I'm trying to figure out. Department of Justice got, they know, U.S. Inspector General, everybody. So there's a whole investigation needs to take place here. Yep, these are all Alex Murdaugh's brewery. Yeah, these lawyers, yes, they are. So I don't want to hear shit about nobody had the awareness what was going on when one of these bad apple motherfuckers, when you see this shit that they're doing down and here, just imagine, ain't no telling what they're doing. Okay, so when some bullshit happened, just like what happened with Alex Murdaugh, you think a motherfucker didn't know what he was doing? You think somebody didn't have the awareness? Yes, they did. And they didn't speak up, they didn't speak out. They're overlooking and sweeping under the rug and shit like that, scratching his back, buddy, pow, pow, and shit like that. Now he done went and done something. Okay. Then everybody want to act surprised. Surprise, surprise. You ain't gonna have the opportunity to be surprised, baby. Everybody got the awareness. Everybody and their mama. It doesn't matter from each and every corner, each and every aspect, and everything, any nook and cranny. You know about this. You know about Karen Phibbs. Everybody does. All right. Period. So I don't want to hear shit. Okay. And when they come out talking about, oh, I'm sorry, and I didn't mean, and all that, that's a whole lie too. They're all sweeping under the rug. They're all piece of shit. So Chris Brown been sitting on this case for I don't know how long. 22CB007866, 22CB008947, since November of 2022. He has not made any ruling on any motion or pleading whatsoever that's pending before the case that's pending in the court. And there's a lot of them. He hasn't ruled on none of them. Period. My money is not in a trust account. It's not in a court registry. It's not with an innocent third party that doesn't have an interest or ownership in it. So what that would mean that Aetna Resources would not have my money in their hand. CBS would not have my money in their hand. They would have at least sent it over to their attorneys. Their attorneys themselves are the true third party that would not have no interest in it. Okay, they have not done that. They have it. They have it in their hands. Okay, EEOC says that because Aetna doesn't have the funds and the money in their hands, that's the sole reason why they're not able to enforce their MSA agreement. That's a rationale behind why they won't enforce it. Okay, but they absolutely do know that Aetna does have my money in their hand, that Aetna did not put it in a court registry. Okay, they know this. Yeah, so they're discriminating against me. Who's gonna do something about it? Who's gonna do something about it? Hello? And Thomas Cocklaw thinks he's an attorney and he ain't shit. He ain't no attorney. He got a fucking master's in arts. Okay, sitting up here quoting case law and shit like that. That's not applicable to the instant. Okay, he's talking about that by Ohio law. Once somebody puts the money in the court, it's no longer in their hands and all this. Right? Okay, then that's fine. That's how it works in a true interpleader. But this is a fake bogus interpleader. And actually, there is no money in the court, and Etta does have it in its hands still. And you know this, Thomas Cocklaw, non-attorney ass sitting up here trying to pull some fucking case law and shit. Get out my face, boy. Get out my face. You want to go be an attorney? Go sit for the fucking L side. Okay? You're discriminatory. And he's a whole black man. Okay? It be your own. It be your own kind. Okay? So it doesn't matter. Okay? He's discriminatory. He discriminating against me because I'm black. Maybe he don't like me because I'm a light-skinned black woman. Maybe Thomas Cocklaw don't like me because I'm a dark-skinned black woman, and he ain't trying to see nothing to work in my favor when I ain't never done shit wrong. Maybe so. There are blacks like that. You do know that, right? That's against each other and shit like that. And be on the white man's side or whatever. Okay, it's unfortunate that they got to come down to saying some shit like that. But yeah, they don't get no fucks. They ain't down with you or nothing like that for just being down for what's right. And then when you be down for what's right, but then when you see the shit's really happening to a black person, you're like, no, that's not okay. Because I'm black. That can happen to me. That can happen to my black kids. That can happen to a black family member of mine. That's how we have to stop this so everybody gets fair treatment. It's really sad that I have to boil down the rest, but that's what it is. So EEOC is not enforcing the EEOC MSA agreement, okay, when they know the absolute truth of theft, felony theft, and everything like that, and they cannot prove otherwise. They cannot prove that there's any money in any court registry and out of Aetna's hands because it's not. All right, boom. That's why you don't never see nobody coming on shit of mine, refute or rebut anything because they can't. Anyhow, I'm gonna finish reading this and I'm gonna get the fuck off right here because I got some more shit to do and I got something else to show you too. Later. My neck is hurting a little bit. All right, did I read all that? Okay. This court filing of plaintiff is frivolous and disguised as an interpleader. Aetna Resources LLC, a CBS company, by and through its counsel, Richard Diageo and Alex Frondorf, has strategically devised a plan to misappropriate the property of defendant April Clark in the amount of $15,028 in efforts to conceal the true accurate facts related to this matter before the court. Plaintiff Aetna Resources LLC, a CBS company, counsel, Richard Diageo and Alex Frondorf know and understand their own roles, what I meant to say, their own role in the deliberate intentional theft and seizure of the equitable property in amount of $15,028 belonging to the known rightful owner and beneficiary, defendant April Clark. Richard Diageo wrote in an email correspondence dated October 18, 2022, Ms. Clark, I understand your position. I have the actual email to them. And I will revise the draft of the private settlement agreement that I had sent to you the other day to reflect the existence of the fee dispute between you and the Spitz firm. I will send you the revised version of the private agreement later today. Regards, Rich. Okay. When notified by defendant that no settlement agreement in any form will be signed if the verbiage as it read in the initial MSA and general release allocating any of defendant April Clark equitable property to Smith's law firm. On October 18, Richard Diageo wrote Ms. Clark as requested. I have revised the settlement. He wrote this. Paragraph 1 specifically to acknowledge the fee dispute between you and the Spitz firm and to delete the language specifically requiring payment of the $15,028 in a third check to Spitz. He did that. He admitted it. Please see the attached Word document containing red line track changes which reflect the revisions. I don't have no reason why. Craig. He wrote this. If you're okay with the revisions to the settlement agreement, please let me know and I can send you a clean version, okay, of the same so that you can sign it. I am also re-forwarding all of the other settlement related documents that I had sent yesterday just to be comprehensive. Thanks, Rich. Richard Diageo wrote an email correspondent dated October 22, 2022. Good morning, Tricia. I'm getting ready to write a pretrial statement too. And this is basically what I'm gonna have all of this in there, and I'm gonna go back and put a whole bunch of other dates and shit like that. I'm not an attorney. I'm not trying to be. They forced me into litigation here, so I have to do what I have to do. I did go to Capital University Law School as well, not for the same time that they did, or to be a law student. I'm a legal nurse. And I went for legal nurse consulting there. And then that was a 15-month program. Then I stayed another 6 months to be a life care planner. So Capital University Law School is an excellent school. They teach you very well, don't they? But I'm not an attorney. I'm not an expert. I'm just doing the very best that I can because I have to defend myself. And because I'm being wronged. And it's deliberate, it's intentional, and it's with malice. It really is. It's not okay. Like, I can't believe that people do this to other people. And so it's being done to me. It's really tearing me down. I really do have mental health issues already. It's exacerbated, and I'm really just torn down, and no one cares. But hopefully, out of this, by me bringing the awareness and making sure that it's out there for the public, that things like this won't happen to you. This is very important. This overarching interest is employment. All right, so the employment is of public interest and public policy. And so these types of things are just the fish bones of it, right? So so wrongful termination, filing of EEOC and whistleblower or civil rights claims, federal claims, or whatever under protected activities that you're allowed to do, and then someone fires you behind it. These are things that are fundamental in our society. And also what people who are at the forefront of leadership and in your elected public roles are really utilizing as their platform to advocate for you voting for them. So you need to know that this exists, and where a real citizen has gone through something where these very public officials and things like that, and these attorneys and judges and all of this that are supposed to uphold the laws, you need to see and know what they're really doing in a true case scenario. All right. And this is in the practical world. This really happened and it can happen to you. So you need to have the awareness of what's going on for that purpose. All right. For that purpose. And it's very serious. And I'm already an advocate anyways. And so, I go through certain things in my life that I believe, must be necessary for me to carry the burden, just be beat the fuck down, and not have shit. I don't have shit. I was like, oh my God. So, yeah, but I'm gonna keep on advocating. I'm gonna keep on doing what I have to do because I believe that it's something else. Like, I believe that it's some other divine thing that has me doing it. I just asked the Lord one day, I said, Lord, I want to see the results. I want to live to see the results one day. But it's okay. If I don't, I'm fine with it. Anyhow, let's get back to it. All right. Just know that behind the scenes, I've been advocating for a very long time. So now I'm just at the forefront of it because I'm sick and tired. The time is up for wrongdoers. You will be exposed, and then public opinion is what matters. And so, therefore, that's why we're out in the public. You can make your own decision. I'm not forcing you to side with me. I'm telling you my side. Go hear their side, and then you decide. All right, there you go. All right, now, so Richard Diageo wrote an email correspondence on October the 22nd. Good morning, Tricia. April Clark has notified us that she is disputing Spitz Firm's claimed attorney fee for $15,028 and that she has filed a disciplinary complaint against your firm in order to dispute that fee. I did file disciplinary complaint against them. Like I said, I'll Supreme Court disciplinary where they don't do shit. Okay. But they really don't even really do anything with disputed fees. This law firm would literally have to sue me if they were worried about their fees so fucking much. But Richard Diageo already told me that they know that they can't get their money from it because they don't have any actual work. He already told me that. See, he's two-faced, but he won't tell them that. I mean, you know what I'm saying? Yeah. As a result, CVS will issue a $15,028 check to April Clark, as that amount is technically part of the overall settlement amount due to her under the settlement agreement. So is he aware that the entire sum is due to me under the MSA settlement agreement and his very own? The disbursement of the money isn't broken down any differently. Okay. So yeah, he does absolutely that. But do you think they told this part to the court? Mm-mm. Because they're masking the truth or spinning the narrative. They're only telling half truths, which are lies. All right. As per, and he gives the case law. All right. And he gave her a copy. This one he thought it was cute. Okay. He said the Spitz Firm's purported attorney charging lien is not enforceable. They don't have a lien. All right. There is processes involved. Even if you say you have a lien on somebody's settlement money, you have to do certain things. You have to notify the person. You have to notify me. Like you have to send a letter or something like that, certified, saying that you gave me the awareness that you're going to file a lien on my property. They have never done that. They never have done that. And they won't be able to show that they ever did it. If they did, they should have the green card to say that I got it. Okay. They never did it. Okay. There is no lien, there is no judgment, there is no court order. Period. So why did somebody steal my money? Why did somebody just gain control over my money? And why don't I have it? Why did somebody just do that? Okay. Somebody needs to question that because something must have occurred to make them decide that they needed to do that. Right. All right. So, blah, 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 blah. Yeah, so the lien is not enforceable against CVS Aetna, but rather only against Ms. Clark as your former client who purportedly owes you the fee. Please be guided accordingly. Okay, so yeah, they know exactly what they're doing. There's no lien, so nothing's enforceable because there isn't a lien that exists, and I won't be able to show you one. Now, Spitz, do you want to come show your lien? You want to show any actual work that you did? By all means, please do. They won't be able to. All right, on October 26, 2022, Richard Diageo run an email to Trisha Breed, Lover Spitz. Good morning, Trisha. April. Oh, I just put that in there again. Okay, so then she said to him, basically, that check need to come to us, like you told us, 15,000 was coming to us. So, Richard replied, oh, I didn't put her email in there. So what? I'll fix it. Anyhow, she said actually Ms. Clark repudiated the original agreement that called for issues of a check to your firm, and the settlement agreement that Ms. Clark ended up signing does not require issues of a check to your firm. All right. Now, I didn't repudiate it per se. He voided it because of what I already told you and stuff like that. But I mean, it's a repudiation at the end of the day. You might say I'm not going to sign this shit, right? I'm not going to agree to shit. Okay. He said, rather, the signed agreement merely acknowledges the 15,028 fee dispute between Ms. Clark and the Spitz firm and the disciplining action relating thereto, and states that Aetna will act in accordance with the law with respect to disbursement of the 15,028 amount pending outcome of fee dispute. We view the KISS lien. He just goes over that, blah, blah, blah. You can read it. Okay. So in other words, a fund that is not created until paid to your former client which I haven't been paid. And that the attorney's sole remedy is to pursue the lien against the owner of the settlement fund. So they have to, the sole remedy is for them to pursue the lien against me. There is no lien against me. I'm the fund owner. Richard Diageo knows I'm the rightful owner. So does Alex Frondor, so does Whitley Medicine, so does CVS, so does Aetna Resources, so does each and every person that knows about this case. I am the rightful owner. They know it. They stole my money. So, when are they going to jail? Okay. So your former client, April Clark, okay, and not against the alleged tort foreseer payer of the settlement, which was Aetna. They need to pay me the settlement. The alleged tort foreseer. All right. So they have interest in the money. They own it first, right? They're the owners. This comes out of their revenue. Why is there interpleader in the court? Why was this found in the judicial system? Why is it running up court costs? Why is your taxpayer dollars being utilized for this bullshit? It's fraud in the court, it's felony theft. Who's going to be held accountable for that? What are going to be the consequences? When there's no consequences in these types of actions and behaviors continue, right? Who's going to pay me? Where's the damages? Aetna settled with Ms. Clark for a specific entire sum. Do you see it? For a specific entire sum. Richard Diageo wrote that. Why don't I have 15,028? Why is there a balance? Why wasn't it all paid to you? Oh, Jesus Christ. But they don't like me. They want to retaliate against me. But I'm the fucking victim. I ain't done shit wrong. You can decide though. Okay, so yeah. So the entire sum and attorney fees, if any, there's no attorney fees, okay? I'm pro se, I did everything on my own. They did not ship for me, okay? They're payable solely out of that sum. All right, they have to come after me, Smith's law firm, if they feel that they can. They don't feel that they can. It's what they told him. Okay? They didn't know he's gonna come and tell me. They don't have no actual work. This is a whole waste of fucking time. These motherfuckers put my life at risk here. I'm getting ready to be homeless. Who's gonna pay me? Anyhow, he said, I trust this clarifies our position. That aside, in view of the disciplinary proceedings against you and your firm, and the fact that Ms. Clark is challenging the amount of your fee in those proceedings, it would seem rather pointless for your firm to file an action against Aetna to collect the amount of your claimed fee. The court will not be permitted to order payment of a fee whose reasonableness is being adjudicated in the Office of Disciplinary Counsel. As such, I suggest that your firm refrain from filing action against Aetna to collect the disputed fee, and instead make your case for the full fee in the disciplinary proceedings. Thank you. All right. So then he says, hello, Ms. Clark, the Spitz firm has threatened to file a lawsuit against Aetna, against CVS Aetna, my firm, and both me and my colleague Alex Frondor personally, if Aetna sends the $15,000 28 disputed attorney fee amount to you. That now he's backtracking after he already told her that, because she said, well, you're the one that said you sent us $15,000 check. We're going to sue you because of what you did. And you asked us for our W-9. So now he's like, oh shit, they're getting ready to come after my own assets and Alex's assets. Shit, and the firm? Damn. Well, they have drafted a lawsuit and have stated that they intend to file it this Monday if an agreement is not reached as to the handling of those funds. Would you consent to CVS Aetna sending the $15,028 disputed amount to my firm to be held in trust pending the outcome of the fee dispute between you and Spitz and the firm? They have to ask you for consent. I said no. Once we are advised as to the resolution of the fee, see, they're playing mediator now. They're totally out of line. All right. Once you are advised as to the resolution of the fee dispute, We would then proceed to distribute the funds in accordance with that resolution. This would seem to be a reasonable solution to the dispute. Note that this would not impact my client sending the other 2 settlement checks to you in accordance with the settlement agreement. There should have been 2 checks only, 1 check for wages and then the other check that would cover the entire amount or everything sent to me. Okay, that's how it works. You see the bullshit? Okay. Note, blah, 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 blah. I expect those 2 settlement checks to be sent to you in the very near future, certainly within the time specified in the agreement. Kindly let me know as soon as possible whether you will agree to my firm holding the dispute of 15,028 in trust pending the outcome of your fee dispute with Spitz. I said no. All right. I said I did not agree to holding any of my property in any regard. No separate action exists in the fee matter, and Spitz firm has no right to my property. A subsequent update to the disciplinary council will be submitted online today as this matter continues to cause issues with me, closing out the harms I have suffered. Each time I am outreach regarding this matter, which is settled, my anxiety, PTSD, and my major depressive disorder is exacerbated. I look forward to the receipt of the entire agreed settlement amount as outlined in the settlement agreement. Thank you. He said, I'm not asking for you to consent to have the money sent to Spitz. I was asking if you would agree. I have to have the 15,028 held in my trust by my firm, okay, Littner Mendelsohn. Spitz has threatened to sue me and Littner and CBS Aetna if we send the 15,000 disputed fee amount to you, as they think they'll never be able to collect it from you. Where did he get that information from? Where is that my problem? That Spitz don't think that they can collect their money from me. Where is any of this shit my fucking problem? Where's my fucking money? Okay? It ain't gaining no interest, not shit. And they beating me down. They beating me down because I'm a Black person. They said, fuck her. She's a dumbass Black person. Okay? We're going to keep on discriminating against her. We're going to do the same shit that led her to bring the federal case against us. Okay? To bring the Ohio civil rights cases against us. All of that shit. Okay, we keep on retaliating, we retaliated and all that, and that's where the OSHA whistleblower, that's where all this shit stemmed from. Discrimination, retaliation, and all that is the underlying basis of all this shit. All right, and we're gonna just keep on doing. Then we're gonna let EEOC get on board and discriminate and retaliate against her as well, and tell half truths and lie and do all that. But she's a dumb, stupid Black person. And we know that dumb, stupid Black people don't get anybody to stand up for them, not even their own. So, all right. I went on and said, if you would consent for the 50,000 disputed fee to be held in a trust or escrow by Littner, it has to be in a trust or escrow so it can get the interest and stuff like that. It's not in a trust. It's not in an escrow. It's not in a court registry, nothing. And it hasn't been, so it's damn near a year later. And that's why nobody's saying anything on the case and they're not doing anything about it because they want it to be covered up. So that's why I have to let it be known down here. And I had to report them. And all this shit is already uploaded to plenty of people, to Congresswoman Joyce Beatty, to Senator Sherrod Brown, to EEOC themselves, to the U.S. Inspector General, to the state Inspector General, to everybody, anybody. They have all the actual emails and everything. Yep. Even the Ohio Attorney General, they don't have jurisdiction, but I put everything on their shit too. It's all public record. It doesn't matter. Wherever you look, you're going to find it. And wherever you call and request public records, it's going to be there for you. All right. So I'm tired of people revoking my rights and shit like that and treating me like shit. So, yeah. Now, I said, Mr. Diageo, I do not consent to any holding of my property by your firm. I have stated this numerous times and will file a grievance against you online immediately. If you ask again, I'm being harassed at this point. Please cease immediately. Yeah, like, I'm really nice. I'll just try and be nice. Like, why are you bothering me? Like, I mean, seriously, like, and I really thought he was a cool dude. I mean, I don't have nothing against none of these people. I mean, not even the true employer do I have anything against. They're vicariously liable for the shit that their employees are doing. So I don't have anything against them. They have to defend them, but they were fired the wrong one. And they're bothering the wrong motherfucker, really. But anyway, I said defendant April Clark has notified this court in letter to the judge of the half-truths, unclean hands, fun narrative of the actual facts related to the totality of circumstances before this court. And to date, there's been no response or ruling on any of the several motions pending in 22 CP 7866, Judge Chris Brown presiding. The pending matters collectively inclusive of this instant and 22 CB 008936 before the court all stem from the decision and risk Aetna Resources LLC and its attorneys to steal defendant April Clark property in amount of $15,028, which there is no lien, no judgment, and no court order on the face of the earth that gives anyone the right to gain control over without consent, and no express or implied was given consent. It wasn't. It has to be express or implied consent. Okay, and then it was. Okay. Defendant April Clark never provided consent to hold her equitable property, and therefore Alex Rondo from Richard Diageo of Littner Medicine PC Counsel for Aetna Resources LLC, a CBS South company, decided to seize defendant April Clark's property without consent and utilize their legal expertise and legalese to fraud the court with a lie to cover the unprofessional and unethical acts of Richard Diageo during EEOC mediation of negotiations. They didn't think I had no good sense. I got plenty of sense. I'm not an attorney, but I have a lot of good sense. And anybody can sponsor me at any fucking time they want to. Go ahead and send me to law school. Anytime. You can cash out. $ Care Advocates. CAREADVOCATES. All right. 444. Cash at me and I'll get to schedule the LSAT and do what I need to do. Okay. Thank you, Jesus. Now. And that should say the filed bogus claim. You're like, oh, bitch, we don't need you to read it to us. I want to just chit chat with you when I get to certain parts. That's why. They should say they, huh? They filed a bogus claim, which has been reported to the FBI. It has. State Inspector General, U.S. Inspector General, Congress Representative Joyce Beatty, Department of Justice, Criminal Division, Shared Brown Constituent Advocacy, Joyce Beatty. Congresswoman Joyce Beatty's office and Sherry Brown placed inquiry with the U.S. EEOC post notice, and an investigator has been assigned as EEOC mediator. I didn't even finish that thought, child. I'll be writing. Follow-up and investigation and requests for response are currently in progress. Plaintiff by and through Alex Fronder failed to tell the court the fact that Salvador Lopez, EEOC mediator, on the same date as Richard Diageo, revised the EEOC MSA agreement post notice of intended report of each to deceive and place duress on defendant April Clark to sign the initial EEOC MSA. On October 17, 2022, Salvador Lopez wrote an email. The only conversation we had with them, prior to the mediation, which you were made aware of, is it was just to confirm you ended the attorney-client relationship. I do not benefit from trying to trick you in any way. This was just a misunderstanding that can be easily resolved, but if you do not have any confidence in me, I can speak with the coordinator to see what will need to happen next. Salvador Lopez, EEOC mediator, so that. Yep, so this is what they're covering up, and I'm getting fucked over. All right, so Richard Diageo and Salvador Lopez revised both the MSA agreement and general release agreement, removed any and all specific language, allocating $15,028, and or any amount of plaintiff April Clark equitable property in which Aetna Resources LLC currently holds in hand and control and has not placed stolen property in a trust, court registry, or with an innocent third party with interest or ownership in equitable property. Each entity has received requested pertinent information and documentation to support the aforementioned in this instant correspondence. And the Resources LLC by and through Alex Fronders have filed a frivolous interpleader with this court that has incurred significant judicial costs and continued to cause severe harm to plaintiff who is the victim of a crime. Felony theft of the property of defendant April Clark in the amount of $15,028 has undoubtedly taken place and is considered to be continued tactics of retaliation and malicious intent against defendant April Clark. The court is fully aware of the extended duration related to the ruling on any motion in the matter 22CB007866 filed November 19, with no ruling on any motion pleading since the filing date appears to be a lazy judge instance, further harming plaintiff in this instance. Okay, this lazy judge. Defendant April Clark notified all parties in email on February 16, 2023. Hello, it appears I need to file a writ of mandamus with the House Supreme Court, and that is my intent. Thank you. On February 21, 2022, Jacqueline Bajas notified in email correspondence to all parties in this matter. Thank you all. The court will move forward on the motions and we'll be in touch if any conferences are needed in the future. That was back in February. That man, Chris Brown, ain't ruled shit on none of the motions yet. Not even yet. And it's September of 2023, baby. He ain't done shit. They ain't in cahoots. So it's a hearing coming up, and I filed demand for jury trial. And I'm indigent. I don't have any money. I don't have anything. Yeah, so I filed affidavit indigency too. But I want the public to hear this. So maybe you'll be called as a juror. They feed you in jury duty. I like jury duty. All right. So I said defendant April Clark feels biased and prejudiced. I will take this to the Supreme Court. I'm telling you right now. Because Karen Phipps, she could deprive my rights, so can they. And that's exactly what they're trying to do. So the public has to know about this. The public has to know this is taxpayers' dollars and all this to fight a fucking interpleader. Interpleaders do not involve all this. Is a whole fucking litigation. That's not what interpleaders do. They started this shit. Then they put in a court record that they didn't want to be in the fight between April Clark and Swiss law firm. Bitch, y'all started it. Y'all started this fight. Yes, they did. Who will hold them accountable? All right. So anyhow, defendant continues to suffer severe harms as a direct result, whereas all parties know and understand there is no lien, no court order, no judgment against the 15,000 equitable property of the rightful owner and beneficiary already known to plaintiff and the Resource LLC and its counsel, Richard Diageo, and Alex Rondor of the Minister PC and defendants Swiss law firm at 22007866 and 22CV008947 cases that were consolidated 324 order of the judge in this matter, Michael Holbrook. Due to Rich Diageo inability to gain consent from defendant April Clark to hold the money, pretty much, that belonging exclusively and solely to her, in which Karen Gasser Esquire signature reflects on an EEOC MSA agreement signed October 22, whatever, reflects on the general release and the EEOC thing. Her signature on both of them was to be paid in total and entirety, inclusive of the 15,000. To the EEOC charging party in 532-202-202-705. The equitable property of defendant Clark in the amount of 15,000, blah, 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 has been willfully and intentionally seized by the plaintiff in this instance, and his attorneys, the Master Factor Richard Diageo, has previously contacted his law firm, Trisha Breedlove, informed he will be issuing the firm a check for $15,000. Diageo neglected to immediately inform Trisha Breedlove of his law firm that he actually revised the settlement agreement to ensure no specific language allocated 15,000 and 15,028 was illustrated. And he provided the red line word doc version of the revised version of the release to April Clark. For April Clark to proofread and approve prior to completion and finalization. The only cause for plaintiff attorney Alex Rondorf to file interpleader on November 19th was to cover his colleague Richard Diageo's unethical acts and figure out a legal process to use that masks the error and negligence of Richard Diageo, spins the truth and tells half of the whole truth. Richard, I don't know, I was typing fast, I don't care. Trisha Breedlove of Spitz told Richard their intent to sue him individually and his colleague individually and the firm due to the fact that Richard promised Spitz a check for 15,000 and did not follow through nor go back and tell them he voided the agreement after being accused of trickery to seek forged signing under duress. Email correspondence exists to validate each and every factual, accurate, and true detail noted in this letter and has been uploaded and provided to each agency aforementioned for any investigation to the crime and unethical practices of parties named in 22CV 007866, 22CV 008947, and 22CV 8936. The actions of Epic Resources LLC, a CBS of company by and through this counsel to use the court and otherwise effective and legitimate legal process to merely act in its own best interest and cover up its own port of professional or ethical practices to avoid accountability is continuing harm to defendant April Clark. These acts are malicious, atrocious, egregious, and outrageous to say the least. Plaintiff in this instant, April Clark respectfully informs the federal courts, Judge Chris Brown, Michael Holbrook, and all parties of interest that a report of theft of property with Cleveland Police, Columbus Police, and New Jersey Police, as well as each attorney's disciplinary board. There is awareness of the crime of theft in this matter and associated case, blah, 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 blah. Okay, you can read that. Defendant April Clark continues to be severely harmed as a direct result of the ill will, wanton, and egregious actions outlined in this correspondence, and there is no cause whatsoever in any Black's Law Dictionary or case law to substantiate why the property in the amount of 15,028 is misappropriated from defendant April Clark. The funds remain stolen, belonging to the rightful owner, defendant April Clark. Defendant is aware The property remains in the hands of Etna Resources LLC, who breached the general release and ELC MSA settlement agreements on purpose and forced litigation onto defendant April Clark, knowing it seized her employment by way of wrongful termination immediately following participation in protected activities as determined by Ohio Department of Job and Family Services unemployment and decision to allow unemployment benefits, noting job loss by no cause of defendant April Clark. Okay. Etna Resources LLC, a CBS company, and its attorneys tricked defendant April Clark into dropping all employment claims and agreeing to settle the claims and pay the total settlement amount in full and entirety and total directly to the defendant. To the defendant, and it says plaintiff, and they failed to do so to hide the actions of Richard Diageo, which warranted Spitz Law Firm sending him notice of their intent to sue him, Alec Farmer, and their individual assets, as well as Littler Mendelson, PC. April Clark is being harmed by no fault of her own and are not in any court registry, trust fund, innocent party, blah, blah, who cares? Further, defendant Spitz Law Firm acted in its own best interest, not in the interest of the plaintiff. I meant to say defendant, and it has no upfront costs. I'm gonna have to amend that. So, I'll probably have to amend that. What you think? How many times did I have that in? Because I had to put this in another case too. That's why I got freaking confused. Because I had to also put in that other case. But theirs is a little bit different. Because I am plaintiff. I'm plaintiff. I mean, it could go either way. Because I'm actually plaintiff in the other one. I'm plaintiff here. Yeah, so it says over here, it basically says like, because these are consolidated. All right. And then over here is versus me. This is at all. I'm defendant A. That's defendant B. So, that's how it pretty much would look if you were to type something up like this. So, yeah, either way, doesn't fucking matter. I'm not putting this back in, and I have to put service on it and everything. All right, so where else? All right, I already read all that. Yep. Okay, yeah, we got down here to the Spitz Law Firm thing, just basically saying that defendant April Clark does have, okay, I said, what I say? Defendant Spitz Law Firm acting in its own best interest, not the interest of defendant April Clark. It has no upfront costs associated with any of defendant April Clark employment claims, which they don't, because they said something about, and then one of their things that you need to pay what costs Spitz fronted. Well, they didn't front any costs. They haven't fronted any costs. All right. At all. Period. And they won't be able to show that. So, and they know that. Okay. And when it gets into the court, they have to show their actual work and they have to show all that. And they don't have it. And so that's why they went to Richard that they don't think they can recover their costs, because it's just a bunch of bullshit. See what they do? They need to be investigated. And somebody needs to go comb through all their cases and see who else they fucked up too. All right. I don't care nothing about that shit. I just care about that all these motherfuckers bothered me for no reason. I didn't do nothing to nobody. And no actual work performed on behalf of defendant Clark and will not be able to demonstrate either in any court of law, and they won't. So, however, defendant April Clark does have all her actual work, which I did, inclusive of each and every employment claim filing, motion pleading, research discovery, evidentiary work completed, letter or alternate correspondence, interview and or discussion with Littler Mendelson prior to hire defendant Spitz Law Firm, discussion with OSHA investigators, discussion with the ELC media, discussion with Ohio Civil Rights investigator, and any communication of evidence an investigator may have requested as provided by plaintiff, not defendant Spitz Law Firm. Yeah, Spitz did not request pay stubs and employment history and statement of employer, nor place any legal holds due no research whatsoever and has none to show, and certainly no research was completed by way of case law, and Spitz will not be able to show any. This instance was a forced case as well, and defendant April Clark has been harmed severely. Spitz law has no evidence of any upfront cost or expense incurred in which it paid on behalf of defendant April Clark to fight any of defendant April Clark cases, inclusive of the federal case, Ohio Civil Rights, the ELC, the OSHA or whistleblower. Yeah, and defendant did not represent. Yeah, so it's kind of confusing in here because I am the actual plaintiff. Too. So it's kind of weird. Prior to or during the actual MSA court or charge on behalf of defendant April Clark, Spitz law firm never participated in any conversations with EEOC mediator, OSHA investigator, civil rights investigator, nobody. And in fact, defendant Clark had to ask EEOC mediator and the House civil rights investigator why they would continue to call her directly when Spitz was hired on. Spitz did no actual work on behalf of defendant Clark, and it cannot. All right, so the fact is, defendant April Clark is and has been pro se and incur her own costs and put in her own time and labor in which Spitz law firm would like to pass on to the court and public as it is their own, yet it is not, and they will not be able to prove it. Okay. Hence the reason why Richard Diageo alerted plaintiff via email correspondence is that Spitz told. I'll change it. I'm not going to re-update because I'm a plaintiff and a second defendant, so they can figure it out. Told him they did not believe they could recover from defendant Clark. Oh, alerted plaintiffs. Oh yeah, okay. Yeah, he's like that one. Notice attorney Richard Diageo does a lot of both sides of the defense plan. Okay. Nevertheless, Spitz law firm has no actual work of its own and will not be able to show at any point that it does. And all work defendant Spitz does have is the actual work of defendant April Clark, in which she can show all her actual work, the mechanism in which it was distributed to Spitz law firm, and call witnesses from each aforementioned agency or as necessary to speak for themselves and validate defendant April Clark claims. Okay. Plaintiff and their attorneys have devised a plan to deceive the court and participated in unethical and illegal practices that has caused and continues to cause defendant April Clark severe harm. Defendant April Clark requests the court to alert of where her equitable property that was stolen by Richard Diageo and Alex Frondor post request for consent to hold via email sent by Richard Diageo to the plaintiff was denied is located as of September 9, 2023. This case has significant judicial costs associated with it and plaintiff and was deliberately filed. It is a frivolous claim disguised interpleader filed by plaintiff to escape responsibility for its own attorney's actions, which are outrageous efforts to harm defendant April Clark. Plaintiff attorney Richard Diageo, of his own free will, voided the agreement he told defendant Tricia Breedlove of Spitz Law Firm. He had $15,000 check extending from. Okay, and Richard Diageo revised the general release along with Salvador Lopez, EEOC, to willfully remove any specific language previously noted in the short agreements that paid defendant Spitz law firm any of the total settlement amount. Richard Diageo provided his right line draft to the plaintiff to overread and approve to finalization. Yet there is an interpleader in this court for the half truths and outright lies to deceive the court, the public, and continue to harm with additional retaliation tactics on defendant April Clark. The property of defendant April Clark has been seized without consent. It's stolen. No express or implied consent was provided, and all parties in this instant, all them cases, in this instant, and in the other cases, okay, know and understand there is no lien, no court order or judgment that exists, and other resources, CBS, Alex Brother, Richard Diageo, Spitz law firm have full knowledge and understanding of the totality of circumstances revolving around the matter. Property of defendant April Clark has been misappropriated intentionally and deliberately with malicious intent to fraud the court, public, and continue to severely harm plaintiff, which is me. Me in that case. Let's say there's a change. And previously noted in several motions too that remain pending on the record. There is no lien, no court order, no judgment of my equitable property. Therefore, it has been stolen, given no resources, and its attorneys decided to gain control over it under deception. The equitable property is in no trust account, court registry, or in the hands of innocent third party with no interest or ownership in equitable property. Like I had to keep saying it because they don't get it, I guess. Belonging to the rightful owner as known by all parties in this case, me. A crime or felony theft has been committed and defendant April Clark intends to ensure the matter in all three cases extends to the Supreme Court and anticipates filing legal claims against each attorney individually, including prosecution related to the crime of theft. Defendant April Clark requests notice of the location of her stolen equity property and why CBS Health did not send a 50,028 check Richard Diageo noting email to Trisha Breedlove back in October 22 intended to send, as well as who is calculating the interest on defendant April Clark's misappropriated equity property. Richard Diageo was caught playing both sides of the fence and neglected to go back and tell Trisha Breedlove that he voided the agreement that paid $15,000 and no lien existed, and he was accused of coercion and duress. Plaintiff has been harmed. So I meant to say. Both has been harmed and continues to suffer as a direct result of his action and will prosecute as felony theft of property has occurred. All right, so yeah, pretty much. Okay. Yeah. I mean, I have all kinds of shit that I have to keep on doing because these stupid people just keep fucking with me all the damn time. And I haven't done nothing wrong. I need to know where my fucking money is. That's all I want to know. Point blank, period. Okay. All right. What's this one? What's the name? I'm just sleepy. Demand for jury trial. I feel like I don't want to open. Is this the right one? I had to do this like, no, this ain't the right one, but basically this is the same thing that was being said. This isn't the right one because what's the name? Yeah, this ain't the right one. Let me see something. Oh, I want to move this out the way. This thing. I can't move it. How can I move it? Hold on. I don't want to stop the share. How do I move this? Okay, let me just open up. I want to find the one. This is another case that I'm fighting, and this is pretty. It could be actually linked to the other case, 22 CV3620. But this person here was supposed to rent this place, and Columbus Urban League was helping me get out of housing crisis from that. And this person took advantage of the situation. This is my whole cousin. This person is my cousin. Yeah, she's a piece of shit. Yeah, but we get ready to go to trial. So I had to put my pretrial statement in, you know what I mean? In that. And basically, in this particular case, it's 22CV003339. You can go check that out too. Court of comment, please. All these are at the court of comment, please. Because of the prayer amount. Mine are in common pleas because the prayer amount exceeds anything in Franklin County Municipal Court. I did file something on her in Franklin County Municipal Court at first. Then I was like, we need to take it to comment please, where the minimum is 25,000. So anyway, basically, this person, her name is Yvonne Dyer. She actually is my blood cousin. She has a property. It's in the hood in the urban area, whatever. There's a gang territory down there, and they be shooting and all that stuff down there, or whatever, you know. But that's never scared me or anything like that. Plus, I mean, I need a place to live. But down there, she only paid like 2 cents for the fucking property. It's real fucked up and everything like that, I guess. Anyhow, but she was gonna rent it to me for $1,300. But then when she found out how much money I was making, then she came up with some lie and was like, "Oh, it just don't sit right in my spirit. I'm gonna have to charge you this." And she said like 1,400. Then she went up to 1,450. Then she said, "Oh, and in addition to that, you have to pay half of the home insurance through Amazon." I'll pay 75, you pay 75. She just was really trying to fucking scrape me, and I'm her blood cousin. And she had told the other tenant that lived there, because I'm gonna call this tenant, her other tenant, into court to testify. She told her that she, she really need to be charging more for this property, because her friend who lived down the street was getting thousands, like 1,400 for her property. So that's what she was gonna do. I'm gonna have that girl come in and testify. I talked to the tenant. I'm gonna subpoena her there. Yeah, and when this Yvonne Dyer found out that I got in touch with the tenant was telling me everything. The tenant told me that Yvonne started harassing her and stalking her and keep on calling and everything, trying to find out what's going on, and trying to make sure that she don't tell me nothing and all that. Yvonne Dyer's up here putting in PRC for PRC to pay her and all this, but she told Franklin County Municipal Court when I first filed down there with them that she's not a landlord. She doesn't own this property. But she wrote up a whole damn lease contract talking about Yvonne Dyer, landlord. Then when she terminated the lease, one day before I was supposed to move in, actually the contract said I was supposed to move in July the 1st, but she kept modifying it, doing all this shit, doing the weird shit. She don't want to answer questions because I have to check and make sure somewhere's going to be safe and habitable. Look at how much shit I been going through. I should be able to ask questions. People don't like that, especially if they're a slumlord. All right, she's like, you can clean the carpet. I'm not supposed to clean the carpet. That's a landlord do. You can take those dirty ass blinds out and shit like that. That's not for me to do either. I'm gonna provide you with the blinds, but you can take them out when you get in there. Why would I do that when I did that somewhere else and got bit up by a whole bunch of spiders and shit like that? I shouldn't have to do that. The place should be rent ready. I don't need you to provide the blinds, okay? You need to take them out of there. The place needs to be rent ready. What is wrong with people? She's a whole nother one. She's a fucking slumlord. And she sat up here, and the girl told me the whole place was shot up with bullets and shit like that any fucking ways. Okay, I mean, I need to call down there to the detective? As a matter of fact, I think I will, because I'm getting ready to go to court. I think I'm gonna do that. I'm gonna call down there to the detective of whoever's over Shot Spotter, and I'm gonna ask him, is there a way I can get the Shot Spotter report for that particular property, or I might have to subpoena the detective in to talk about the date that it occurred and stuff like that. Yeah, I think I'm going to do that. Yeah, I think that's an excellent idea. Matter of fact, I'm going to call him Monday. I'm going to say, I was renting a property. I'm actually going to get ready to go to court because that place, the property was actually shot up. And I just kind of wanted to see, am I able to grab a public record on that? Or do you have any insight regarding it? She had that tenant pay for the damages of the bullet, but then she also put in a homeowner's claim with her homeowner's insurance. Amazon, the tenant told me that, but she acting like she don't have shit to do with that property. She ain't the landlord. She ain't, excuse me, she ain't shit. Well, what we know is she didn't tell it. We had to do our own evidentiary work and find it out. She didn't tell it. We had to call the Franklin County Recorder's Office and find out who the actual owner of the property is. The actual owner is Court Investments, which is actually her business, LLC. It's hers. She filed it. She's an agent for the business, but that's not how she represented it. And that's not how she wrote up her lease contract. Her lease contract, it just has her as an individual. See, she's renting as an individual. She doesn't want her individual assets touched. So now she's trying to backtrack. So nowhere in the lease contractual agreement does it say anything about Work Investments. Does it say anything about Yvonne Dyer, agent for? It says Yvonne Dyer, landlord. So she is renting it as herself. And also, she's trying to tell the court that she did not actually have a binding lease contractual agreement and trying to get away with it. That's what her attorney is trying to say. He's a piece of shit anyways. Anyway, he done been disciplined by Ohio Supreme Court Disciplinary Council. You can type in his name and it'll come up and it'll tell you he was disciplined for submitting fraudulent paperwork and shit like that into the court anyways. And 6 months he couldn't practice. Okay, so whatever the fuck. Okay, these motherfuckers are shady like hell. Ask for a jury trial, honey. They shady like hell. You hear me? So he trying to say, but no real lease contractual agreement bullshit. I have all the evidence for her ass too. And also, Urban League, they're the ones that was going to pay me for me to move into place, $5,400 because I was in a housing crisis because of 2951 Hubbardton Place, Reynoldsburg, Ohio, 43068. Remember? Retaliatory eviction, all the shit going on with that. I had to hurry to find somewhere else to go. Urban League was going to ensure that I had somewhere to go through their housing stabilization program. So, but part of the stipulation of that particular grant, Urban League is not able to disperse any funds if there isn't a valid lease agreement in place. Okay, so that's where you fucked up too, Yvonne. You know you done fucked up, right? because I'm about to call Urban League in there, everybody that you spoke to, boo-boo, and then the experts in their grant criteria and what they have to have in order for them to even disperse the funds. So they dispersed $5,400 to Yvonne Dyer on June the 15th of 2021. It was in her bank account. They did it by ACH bank attachment. So she got that money long before the move-in date. Okay, the move-in date was July the 1st. So she already had it in her account and everything like that. What do you believe happened? Why all of a sudden Yvonne Dyer would just up and decided she's not a landlord and then these people can't move in? What do you think happened? What happened was very pointed questions about the property and landlord obligations and what she intended to keep up as far as I was concerned was asked. Those questions were asked. All right. What's going on with that stove that he was fixing? What's up with the flies hanging out in the windowsill? And come to find out from the tenant, those flies hanging out on the windowsills because poop and pee and all that kind of shit comes up from the basement. And the girl said, girl, don't you put that down in that basement because the dookie and pee and everything comes up through that basement thing. The septic tank is all messed up. So that comes up through the basement, dookie and all that's gonna get all over your stuff. And she didn't pay me for all when that happened to my stuff. Yeah, and the pipes be busting. It's all kinds of shit in here, girl. The stove doesn't work because every time you try to turn the stove on, it blows the what do you call that amp thing, circuit breaker and stuff like that. She said, yeah. And then when I talked, she said, oh yeah, she didn't want you in here because you were people on task. She was already asking her too many questions and stuff like that. She's not gonna fix anything. She doesn't do anything. She sent somebody named Nate over here. She said, I don't have no problem with him though. I mean, he's nice or whatever, but he just be ninja rigging up shit. I don't care nothing about nobody ninja rigging up nothing or anything like that. I have to make sure a place is safe and habitable. You know, as much as I possibly can. I can't control what's happening on the outside with the gang banging and shit like that. But you know, the property is something I'm paying $14.50. She was charged for $14.50. I have to be able to ensure that it's livable, like, you know what I'm saying? But that she was getting pissed. Yeah, it's true. I have all the receipts. They're trying to get this dismissed too, so we'll just keep an eye on it. I demand a jury trial on that. He's acting like I didn't put it in on time. Well, I don't give a fuck. So, yeah, public. It'll be public then. Okay. Yeah, and even if they dismiss it, it'll be dismissed without prejudice, and I'll just bring the case all over again. If it's dismissed, it's not going to be dismissed with prejudice because it hasn't been adjudicated. So, you know, they just need to quit fucking around. Anyhow, yeah, this is a whole new case. So watch 22CV003339, Franklin County Court of Common Pleas. Watch 22CV007866, Franklin County Court of Common Pleas. Watch 22CV008947, Franklin County Court of Common Pleas. Watch 22CV008936, Franklin County Court of Common Pleas. You can go and look at a deprivation of rights under the cover of law, Karen Phipps case, Franklin County Court of Common Pleas, 22CV003620. All right. These are cases and things that involve some overarching things that can ultimately affect you in your life. So the Karen Phipps is housing. All right. So, and the fish bones of that are everything that I said: safe, fair housing, affordable housing, code, house being up to code, safe, habitability, those types of things, protected activities, tenant rights, landlord-tenant laws, those types of things. Okay. Those are the fishbone areas underneath that overarching topic of housing, right? And so it matters. And so if you, as a tenant especially, want to take a look at that and just understand and know what your rights are, and that your rights, if you live in Columbus, Ohio, and you get Karen Phipps, they will be deprived. They'll be deprived. Yeah, your whole human right, your civil constitutional right, yes, your entire liberty. Yeah, your innate right that you're able to bring a lawsuit against somebody and have the merits of that adjudicated. Yeah, in a court of law. She will take that. She won't even get your deposit back, and you paid all the rent, the entire contract, everything. Karen Phipps, 22CB3620. Don't you ever forget it. Don't you ever forget it, because I never will forget it. She deprived me of my right. She's a whole demon. She's a woman who did this to another woman. Okay, but she's a white woman, and I'm a black woman. So maybe that's why. Nobody cares what happens to blacks. Nobody cares what happens to black women. Okay. Don't nobody care what happened to black men. Don't nobody care. Some blacks within the black community don't care what happened to each other and all this. Everybody want to kill each other. Everybody want to be against each other. Don't nobody want to give nobody no tool, tip, and education how they can get the information and do something in their life too and shit like this. Just a bunch of fucking bullshit. And this Black woman is my cousin, Yvonne Dyer, my blood cousin. And this the shit. And she said, you know what? You can only use one ply toilet paper. Who the fuck tells a bitch what ply toilet paper they could use? Then she had in the fucking lease contract that there was a dryer that came with the bitch. But then after she got the money and everything from, that's what happens, honey. When they get the money and shit like that, they go wild hair up their ass. I paid Krishna Kualatata up front their whole entire lease contract. Wild hair up their ass. Don't never do that. She got her money up front. Wild hair up their ass. Then, oh, I already got the money for the contract and shit like that. So, oh yeah, ain't no dryer in there. Oh yeah, like so she left the air conditioner and everything like that, but you're responsible for that air conditioner. And I'm thinking like, well, have you already tested it to make sure it's operable? I have to ensure that it's operable first before I take on the responsibility of that, you know? I'm like, can Nate clean the carpet up there? I mean, you can just go rent you a carpet cleaner for $75 and you can clean it. Like, that's not how it works. That's a landlord responsibility. Okay? Mm-mm. Why is the screen door shit hanging off? Why is all this shit? You know, like, come on now, 1450. I have a right to ask these questions, and so do you. Okay, you already entered into the contract. She let me in that girl's house, and I found out later that the girl didn't have no idea that I was even in her house because she was still living there at the time. She gave me keys to the place. I had the bottom lock key to the front door and both the side door keys. She gave me those keys while the girl was still living in there. So when I ended up talking to the girl, I said, "Yeah, and I got the keys to the place. I got the bottom." She didn't give me the top lock for that one, but she gave me side door keys and the one. But then she says there's no lease contract, but I got the keys to the place. Yeah, she's a whole liar. She's a deceitful person. She's a fake. It's the type of shit they be doing and playing in the court. Shit like this. Also, it's fraud in the court. I mean, you sit up here lying, you know the truth, right? So basically, we're going to just call Columbus Urban League in and have Audronetta Leitner and Irene Scott speak to the fact that you literally have to have a valid lease agreement in place before you can rent any fucking thing, okay? It has to be there. And they don't take the tenant word for it. What they do is they call the landlord and they talk to the landlord specifically, and they take the landlord's word for it. So Audronetta Leitner actually got on the telephone call with Yvonne Dyer. Yvonne Dyer said she was a landlord. She gave a valid lease and all that type of stuff. You have to have the valid lease binding because or the money won't be dispersed. So if they didn't have the lease, no money would have been dispersed. So how did she get the money in her account if she didn't have a valid lease? Right. Okay. So there was a lease that existed and she breached it and she sent the lease termination notice via email. I'm supposed to be in there July the 1st. She kept extending the dates out. Like, oh, the 2nd, oh, the 3rd, oh, the 5th, oh, the 7th, the other. Oh, well, you're going to actually move in on the 9th. I have all the emails. I have everything. But they're trying to prevent it from even going to court in the first place. So I don't want to see any of the evidence. Okay. So basically, that's what it is. So, yeah, she's just a whole damn liar. All right, so here, in accordance to Rule 1604, plaintiff April Clark hereby submits their pretrial statement. So this is what you have to do. I've already put this pretrial statement in the particular report of this particular issue. I now have to go and write a pretrial statement for the this Spitz law firm, or Spitz law firm in Edmond. I have to go do that, and I'll be very detailed with that too. But these pretrial statements are very, very good for anybody in the public vessel to take a look at. It's all public record. All right. So I'm just basically saying I'm pro se. Yeah. So let's just note that what we're really talking about here is that the plaintiff knows the issue at trial is the damages and remedy thereof post-defendant intentional, deliberate, and malicious act of breach of contract, which caused harm to the plaintiff. There was a valid, legally binding contract that existed between plaintiff and defendant, which was breached by defendant. It is the plaintiff's position that the document was executed by the parties as requested by the defendant, and parties mutually agreed to execute the contract on July 1, 2021. I'll be fucking up. I think I'm gonna have to put this in. I think I'm definitely gonna have to put it in this one. All right. All right. So we're gonna amend that. We're gonna submit this in there today, just so that's in there correctly. In fact, Confirmation of validation of the aforementioned was initiated by Audrey Leiter of Columbus Urban League via direct conversation with defendant. There was a meeting of the minds between plaintiff and defendant, as well as Columbus Urban League Homeless Prevention Program oversight, as a valid lease agreement is a mandate of the grant funding and requirement prior to rental assistance funds being dispersed. 5,400 are prohibited for disbursement under the grant funding guidelines unless a valid lease contractual agreement exists, and defendant knows and understands this to be true and accurate. Defendant was required to participate in the interview to confirm lease contractual agreement exists with Arthur Leitner prior to Irene Scott, Columbus Urban League accounting department dispersing 5,400 directly to the ACH bank account of the defendant. Plaintiff believed the issue at trial shall be the breach of a legally binding lease contract, whereas defendant Yvonne Dyer issued a lease termination email to plaintiff post receipt of funds to secure housing for plaintiff and all known occupants as defendant listed on the contractual agreement and obtain individual identification and social security numbers as conditional defendant lease contract. Because then she tried to sit up here and say like nobody told her everybody was gonna be living there. And that all of these people are emancipated adults anyways. And this and that, like, why does that matter? I don't give a fuck who lived with me. As long as you getting rent, it doesn't matter. You knew all these people, bitch, these are your family members. You really sitting up here playing. Let's let this court know that these your family members and you asked for all the fucking information, bitch, while you sit up here playing. All right. So I said plaintiff intends to demonstrate the existence of a genuine contract, plaintiff's performance, defendant's breach, and damage or loss. All right. Under Ohio law, a party who breaches a contract is liable for damages. In this instant, mutual assent expressed by a valid offer and acceptance, adequate consideration, capacity, and legality is present and can be substantiated with evidence inclusive of witness testimony. The contract existed and no question of the fact is of issue. There's no question of that. That's what they're trying to say, that the court needs to see if there's actual legal breach. No, the court doesn't. Not at all. All right, so defendant breached the contract. In the event plaintiff owned defendant, I don't know what I meant there. Yvonne Dyer put it into plaintiff. In the event plaintiff. I don't know what I meant here. So let's just do this. Let's take this out. Defendant Yvonne Dyer put an end to a binding agreement post claiming to be the landlord of the house located at 1744 by the way, Columbus, Ohio. Let's make sure that that's correct. Because I was like thinking to myself, is that correct? Let me see something real quick. I just want to go in my I got so much shit. Let's just put it. Come over 1744. Let's see if anything comes up if I just do that. Moves by a week. Let's see if anything comes up. Let's just put it. Yeah, look, she know all these motherfuckers. Look, here go the lease. First day, July 2021. Yvonne Dyer, the landlord. This is everybody. Okay. All right, this is everybody. 1774. Let's go back. 1774 vitally. All right. Okay, let's finish reading this. And never verbalizing and or indicating on the contractual agreement that she was an agent for court investment, defendant represented as an individual in the lease contract and enter into agreement as such. Knowledge and understanding of the existence of defendant's LLC as owner of parcel was not known until discovery initiated during plaintiff research and evidentiary work, right? So I found out on my own. Defendant Yvonne Dyer breached her duty under the contract and violated plaintiff right to possession and failed to perform. Defendant acts are intentional, deliberate, egregious, and outrageous as she had awareness of verbal autistic baby and 20-year-old has a first psychotic break was a part of family member at risk for homelessness. These household members listed on the contractual agreement are the blood cousins of the defendant. Defendant has caused severe harm and injury in a housing crisis to each person listed on the lease contractual agreement as occupant. Columbus Urban League intervened on behalf of the plaintiff and secured housing stabilization. The defendant failed to perform her duty under the contractual lease agreement, and that is a breach. Plaintiff's performance was complete by merely accepting and mutually agreeing to enter into the binding contract with defendant, as well as plaintiff adherence to the criteria and conditions of which Columbus Urban League demands under their own contractual agreement to receive stable housing initiative program grant funding to assist individuals and family in housing crisis as an effort to prevent homelessness and provide home housing stabilization. This is all true. Columbus Urban League required plaintiff to be at risk at risk for homelessness to provide a summary of events related to retaliation, the landlord and property management at the time. Let's put their name in this case too. Luciana Tata and county, property management. Post plaintiff complaint to government agency regarding condition dwellings, the pending code violations. The city of Columbus had issued the retaliation case. Tierra Ross had in hold status due to a case she was arguing in Franklin County Environmental Court pursuant to environmental case number. So here's that case. It's 20 ERB 72192. That's it's a diamond. Okay, that particular case is what I was talking about from 22 CV 3620. That is where Tia Ross claimed that she could not bring the retaliation case yet against Christian Qualitat and Alcott County NEO because the ordinance that the city had in place to protect tenants from landlord retaliation, posted tenant exercising the right to turn somebody into a government agency about condition dwellings. She had to put my retaliation case on hold because it was being challenged in environmental court, Franklin County Environmental Court. This is that case. It's Diamond versus whatever, right? So that applicable ordinance was being challenged, and that ordinance was section, it's a Columbus City Code, section 4509.07. Okay, so it actually was found unconstitutional. Okay, yeah, it's true. Why don't they? I mean, it's right before your eyes. Okay, so why are they lying and shit like that, right? So all this just paints the whole picture because those cases, right? EBH 060439 at Franklin County Municipal Court, 21 CB 020711. It's a retaliatory eviction that all County NEO portfolio property management filed against me and my daughter in Franklin County Municipal Court, where Judge Green reheard it and then he dismissed it without prejudice. And Karen Phipps over in the common pleas case, because tenants, like Judge Green said, go refile in common pleas. We did because of the jurisdictional limit type of issue, right? Remember? So we go over there and we file a 22CB 003620. Karen Phipps, the presiding judge, she's biased and she's prejudiced straight out the gate. She has an inability to be impartial, right? She went to school with Michael Casson, Capital University Law School, blah, 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 blah. They went during the same time, but they act like they don't know each other. They act like blah, blah, blah. They don't give a fuck, act like they don't have a professional or personal relationship and all this shit. He even put an affidavit about it. It's all bullshit, right? Michael Casson went out and put a 5-star review on all County NEO's Google website saying that Rob Bravak runs a tight ship and all this type of shit. And he recommended all other owners, because he's an owner, to utilize their services. So he, as first person, he gave the recommendation, all owners need to use the services. So he's an owner of real estate, and that's his property management. That's who he was defending in this particular case. Krishna Qualitat never told these people, Kasson and Rob Bravak, of all the bad doings that he was doing, that he's a scammer, he's a con artist, he participates in insurance fraud and all that. He writes wrong incident dates on insurance claims and stuff like that when he already knows the pre-existing conditions of his shackle bushes that he rents and flips and all this. He's an Indian man, lives out in Vegas. He and Bitmore been up here to Columbus to do shit the scam and con people and submit false insurance claims like Amazon and Liberty Mutual. That's what he does. Okay. And then he acts like he doesn't know how to speak English and has a language barrier and everything like that when you talk to him. But then he'll type out in text very clear English. I mean, you can see some things that he, it might be off or something like that, but you know what he's saying. He's making perfect sense. He knows how to scam, doesn't he? He did. He know how to fucking scam. Well, anyway, Columbus Urban League stepped in and said that they would help with the housing crisis, right? You got to give them your firstborn child, honey. They want to know everything that's happening. Why are you going to get ready to be with that place? Because they can repay all this money. They have to substantiate this. It's not them. It's their grant people. They have to substantiate why they're paying all this money for you because they don't want you to be homeless. So they want to make sure you're going to be okay. So they got to make sure you really have a lease and that this person, this landlord, is actually legitimate and stuff like that. They already checked into it. Okay, there is a legal binding thing. So I was still living at that piece of shit, shack bullshit at 2951 Hubbardton Place, Rosebrook, Ohio, 43068. That has over 29 plus fucking public records with 311.gov. Okay, where the city code inspector Christina Conrad gave me the retaliation paperwork to fill out. She came and picked it up. She gave it to Todd Dillard. Todd Dillard gave it to Tierra Ross. Tierra Ross sent me a message saying that she got it. And she later says, after I had to turn her in, like, what's the fuck going on? You ain't sent no update. Oh, by the way, it's being challenged in the environmental court. Then Michael Cassone's on the email thread and everything. Everybody play dumb when they get to court. He's on the email thread and everything. Then he sends me something saying, oh, just so there's no confusion, just want to let you know, here's a copy of the thing. It actually was found unconstitutional, just so you know. But then the city now is acting like they got a whole new initiative. They advocating for tenants and tenants got rights. Well, what has happened? We want to know. City, we want to know what have you changed in the language of the other ordinance in 4509.07 that was found unconstitutional. Now, here you're talking in August and September 2023 that you got a new ordinance, everything's fine. Tierra Ross went and told Ohio Supreme Court that she was working on a new ordinance because the Supreme Court told me, the disciplinary council told me, hey, if it's still within the statute of limitations, then the city can go ahead and bring that retaliatory case against Christian Quantan in our county, and EVH 06043 Franklin County Court of Common Pleas, and 21 CV 020711, where Judge James Green reopened that case and heard and everything like that, dismiss your counterclaim without prejudice, and you went over there to Common Pleas, and Karen Phipps deprived your rights under cover law, your liberty, your human civil rights, and all that. Yeah. 22 CV 003620, deprivation of rights, honey. Well, if there's still time, and they get the new orders and everything like that, then Tierra Ross or whoever's in the role of zone prosecutor now, you just go ahead and file that retaliatory case against those very people that revoked all your rights and everything like that, put their foot on your neck and silenced you and everything like that, try to sweep it under the rug, cover it up so don't nobody get out and go to jail and be held accountable and stuff like that. Yeah. So what's going on? What's going on? Did they get the new one going? Huh? Can somebody ask me? Huh? FBI? U.S. Inspector General, Department of Justice, Criminal Division, anybody? Can you go ask Karen Phipps and everybody? Huh? Can you go look at all the court shits, okay? I'm just named off everything. All this shit is related. Okay? Yeah, can't you? Could you please? Thank you. I've been harmed. Hello. I should have enough money out of all this shit. They're gonna buy me a motherfucking house. Where I ain't never gotta worry about a motherfucker putting me out on the street ever again while I'm trying to take care of my fucking grandbaby that's nonverbal autistic. Okay? All right. And my fucking son had first fucking psychotic break. He's schizophrenic and shit like that. I'm the guardian. I gotta maintain him and shit like that. And I'm going through all this other shit on the jobs and shit with motherfuckers and shit like that. When I ain't doing nothing wrong, trying to advocate, do the right thing for the right fucking reason. I paid all my fucking rent all the way up front. Child bye. Fuck that shit. I'm trying to make sure it don't happen to you. That's the objective. Okay. But I'm gonna need to see who wanted to get to giving to me the ducats. Where's the punitive damages? Where's the compensation? I'm a victim. All right, let's make sure you don't get victimized. Okay. All right. What I need to do is get me the fucking capital to start my own advocacy shit. Okay. And be out here helping people the way they need to be helped. I'm sick and tired of the bullshit. I'm sick and tired of the bullshit. I know how to do this shit. And I'm in the damn vulnerable population, but I've been through the shit. And the vulnerable population people come to me every fucking day and tell me this bullshit they going through. Okay. Too. So anybody want to donate to my initiative? I got a whole LLC, but I need it to be a damn nonprofit. And so my vulnerable population of people I'm out here trying to serve don't have to pay no fucking money for the shit I'm trying to help them do. It's a one-stop shop, damn it. What we do is we do assessments. We do assessments. We talk to the vulnerable populations of people. We find out what's really going on as far as their social determinants that remain unmet. They keep causing the whole health disparities and shit like that. They keep motherfuckers want to keep on talking about. You want to know why there's an issue with health disparities? Why is the social determinants aren't met? Why don't you go ask them? Dummies. They in my inbox 24/7 on my Nurse for You platform telling me all this shit. Okay. Yeah, I'm advocating for them right now, some other shit, and myself and everything. Okay. You want to donate to what I'm trying to do? $ Care Advocates 444. $CareAdvocates 444. Or get in my inbox and shit like that, and I'll tell you where to route my shit to that you want to help me. Anyhow, this was Columbus Urban League's way of intervening and making sure we have somewhere to go. But part of the stipulation for the tenant is you got to find somewhere to go. You got to find available property. Then you got to make sure that the person renting to you is willing to accept a third-party payment. So that's the hardest part. Well, one of my cousins had outreached me on Facebook, and it's like, hey, your cousin just put a place up for rent. I mean, I know you need a place, so outreach her and see what's up. So I did, and everything was cool and fine. I never had no problem with her ever in life. Never. I was like, I know I wouldn't have no reason to have no issue with her. It's so sad that things had to turn out like this. But I try to tell her, I don't tolerate no bullshit. Like, you're not gonna just treat me anyway. I don't care if you're family or not. And it's not okay. So basically, I called her. She said yes, she had a place and everything. And the girl was still living there at the time, but she was gonna be out by the first. So she drafted up the lease and everything like that. Like, you have to have a lease for it, Urban League. Then I called Urban League back. It was a lady who worked over there at that time called Monica Womack. She didn't work there no more. She was like the vice president. And she said, okay. And then she got another lady named Audronetta Lighter on board, because Audronetta is the one that has to do all the verification processes and tell you everything. And she said, like, you need a valid lease, you need this. And she outreached Yvonne. She got on the phone with Yvonne and they talked about stuff. She verified and she got all the information for her. She got the lease, she got the W-9 and whatever else Yvonne needed to give her for that, because you cannot get the funds without it. So once everything that was all received to Audronetta could let Irene Scott, who's in accounting, know to go ahead and disperse the check. So they did. They dispersed the check over to Yvonne. She got that on June the 15th. She never did really even notify me. I had to outreach Columbus Urban League. The Columbus Urban League, they sent me the information. I was like, yeah, we sent that check back in June 15th. And they sent me the attachment. And then Yvonne went, oh, yeah, I did get it. Playing dumb and shit like that. But I was supposed to move in July the 1st. I had everything prepared to go, move, and all that type of stuff. So there's damages involved. She needs to pay me for that. And she literally needs to pay me for that. So July 1st, I could move in. July 2nd, could move in. July 3rd, could move in. July 4th, could move in. July 5th, could move in. July 6th, could move in. July 7th, could move in. I was supposed to, then she said you can finally move in on July the 9th, but on July the 8th, she sent me a email. Let me see if I can pull it up. Sent me an email, said it was a lease termination. She said she was a seasoned landlord and all this bullshit. Like, right before I was supposed to move in. It's all true. And then what she tried to do is backtrack and cover her ass and just try to go ahead and send the money back to Urban League as if that was going to change something. Yeah, she told me don't go over there and try to enter with the keys that she gave me. Otherwise, she would call the police on me. Well, really, I had every right to go over there and move in there. I had every right to, because I had a lease. Because the police already told me, they said, you can go over there and just call the officer there and show him your lease. But, it's not worth all that. So, and God bless me. God bless me with this place. And it's an actual, a really, really nice landlord, really fair landlord. But now I'm faced with the same issue. I can't pay my rent right now. I'm having a very hard time finding a job. I feel like it's something with, valid EEOC and or something. I don't really know. Like, it's something real weird with that. Like, I don't know if it's some type of database or something. I don't know. I haven't done anything wrong to nobody. That's just so bad. So bad. So I just got to figure out something. I have to generate income for myself, which is actually a good thing. When you press up against the wall, that's what you got to do. It's best to be an entrepreneur, work for yourself anyway. And then maybe I can do what I want to do anyways that serve the community, the vulnerable population of people. You have to do what's in your heart anyway. It's like, and that's what I want to do. And I'm an actual nurse, and I know about quality improvement plans. I know about all that. I know about all the shit. I'm actually developing a project right now. In fact, and yeah, it's a whole project. Yeah, it's a whole project. It's actually a requirement for doctor of nursing practice. It's a requirement. And so there are actual models and things like that out there. I've worked in quality, period. Anyway, so it all makes perfect sense, but it's great to utilize different types of models right now to just really bring home the information and make it a little bit more concrete, because at the end of the day, it's going to make me be a better owner of a business and all that type of stuff too. Yeah, and I believe that everybody, I don't care what it is, needs to have a quality improvement plan in place. And if you don't, you're failing. If you don't, you're failing. It's about improvement all the time. I don't give a damn if you don't think there's something. If you think your business is perfect and most effective and efficient and all this shit, you don't need to improve. If that's your mindset, you're not going to last. There's something about your business that you can incorporate an improvement plan, quality improvement plan for, and you should do that coming out the gate. So that's what I plan. That's what I'm doing in our project, anyways. And I think I'm going to utilize the housing. It's like a homeless prevention program, housing stabilization. I'm going to utilize that particular program that's in this city that I foresee needs change and intervention. And I'm going to take one aspect of it, and I'm going to put together a quality improvement plan with that regard. And I already improved with the vulnerable populations of people. They already outreach me all the time. I am going to at some point even present that, to maybe the community shelter board or something like that. I'm in conversation with them right now, anyways, over alternate issues. And I did outreach them and said, if you ever need me to participate in your interprofessional collaborative team, because you do definitely need a quality improvement plan, please outreach me. I'll be more than willing to participate on the team, because you need a team. You need multidisciplinary team approach, all different perspectives and things like that on board. And you need to get a plan in place quick, fast, and hurry. And you need to incorporate a plan, do, study, act right now, immediately, like yesterday. And I can help them do that, just by being a part of that team, because this shit's it's not okay. It's not good. So yeah. Yeah. So right now, basically the things that I am utilizing and what I'm doing, there's actual quality standards out there. There really are. There's a lot of them that they offer you the guidelines and everything. So I'm using the Institute of Healthcare, for Healthcare Improvement. I'm using their approach. That's where the plan, the PDSA comes from. It works. So I'm utilizing that, and I'm also utilizing John Hopkins evidence-based practice model as well in what I'm doing. Yeah, because ultimately right now, currently, I really do have a LLC. It's Care Advocates. I really do have that. It exists, but it's an LLC. And I need donations or capital to serve the community as an LLC, because that would be for profit. The community of people that I'm trying to serve is vulnerable populations. They don't have the capital. They don't have the money to pay for services. So people will have to donate and things like that. So the objective is for me to actually do a nonprofit. Yeah, so I am doing a lot of studying. Can you see this? How about you see it? How about you see it? Oh no. Anyhow, it's a book. It's called Nonprofit Kit for Dummies. So I'm working on that too. I got a lot of things. I got a lot of shit. Okay. So I'm going through this. I got this book, but also I have the Secretary of State here in Columbus, Ohio is really good with providing information. They actually have something that I downloaded. I haven't got to really going through it. I started some stuff. I got a whole business plan. I have a lot of things already in motion. And actually, I will be writing an actual grant proposal anyways. It's as an assignment, but I'm going to utilize it in maybe something that I'll be able to present later. Yeah, I'm utilizing every opportunity that I possibly can to genuinely make change. I'm not bullshitting around in school and all that. I'm not doing that. So any opportunity that I have to take, even an assignment or a project, to make the changes that I know are necessary out here to help the vulnerable populations of disadvantaged people. I'm getting pissed. The disadvantaged people and the people that everybody considers an underdog and they don't give no fucks about. That's over. Because I made it my lifelong project now. I've been doing the shit behind the scenes already. But now I'm really mad. And that was the worst thing that anybody could ever do to me is keep on poking me and keep on poking the bear. I will stay behind the scenes for a while, but now not anymore. I don't have anything else to lose anyways. I don't have anything to lose. So we're gonna just fight for the vulnerable populations of people. And this is my true calling, it's my true purpose in life. And I'm gonna be okay. And so is everybody out here. I'm 50 years old, so I gotta work fast. But I'm making changes. And even with the community shelter board even outreaching me back and stuff like that, the door I feel is open and I got opportunity to really maybe build relationships and network with people and really truly make changes. I just went out and I asked some of the vulnerable population of people that I do talk to in community groups to really tell their own story. Like, I literally need you guys to tell your own story because that's a better way for me to get help and let people see what's really going on because they don't know. Like the one guy, he messaged me back from the community shelter board and he was giving all these resources and stuff, but he's basically saying like there's no waiting list for the homeless shelter and the hotline is supposed to be calling and making sure that people get a place to stay. Well, he doesn't have the awareness that that's really not happening because what did I say? It's the employees, it's not the overarching entity. It's these people in these roles, they're not doing that. So he believes that he knows that the standard procedure says that you better keep on calling till these people got somewhere to stay, but it's not happening. People are living in their cars, they're in their cars with their children, they're in hotels, or they're just in the woods somewhere in a tent under a tree. I'm talking about shit. I'll show you that next. I don't know how long these videos can be, so let's just get through this real quick. Anyhow, my tears ain't for sadness. My tears are sadness for the vulnerable population. But I'm angry. And that was the worst thing that any wrongdoer could ever do, is to piss me off. Your time is up, wrongdoer. Now, basically, this woman, Yvonne Dyer, she was supposed to rent me this place where I was supposed to be able to move in there and all this type of shit, right? So anyway, she breached a contract. So she's trying to tell the court that she didn't breach it, and she's a whole liar. We're gonna call in Columbus Urban League and anybody else. All right. So basically, and also know that there is no city ordinance that protects anybody from any landlord retaliation, no shit like that. Okay. So anyway, the retaliatory action later found to be unconstitutional. These are all the things that have been provided, right? To Urban League, that I had to give all this photos, text, and other evidence on what constituted a need for housing crisis assistance intervention for me. All right, so I had to locate a landlord, which was her, and she's my cousin, by way of family member notice that she had a property for rent. Plaintiff outreach defendant and explained the current situation of housing crisis, inclusive of notice of eviction issue or status, linkage with the homeless prevention program for the entire household of all emancipated adults, in which include persons with disabilities, special needs, warranted disability benefits under U.S. Social Security Administration and guardianship. All right, the guardianship comes from the probate court. All right, so the defendant's counsel's discriminatory statement, because he said emancipated adults. You don't know. why people are there and why an adult might need to be there. Maybe they need supervision because they don't have the adult mindset. They're not developmentally an adult. Who the fuck you think? Get out my business. See, he's a whole piece of shit. That was a discriminatory statement, and what it failed to include in his final pretrial statement to the court, plaintiff alerted Columbus Urban League. He failed to include this about the special needs. I have a nonverbal autistic grandchild. I also have a son with disability as well. They both get Social Security. Hers don't start until October, but he gets his, right? If they're disabled, it doesn't matter. It doesn't matter about shit. Like, get out my business, all like that. It doesn't matter about none of that. Okay. Now, should I put some shit in here about how he got in trouble? And excuse me, Judge, I just want to let you know that keep in mind he was found guilty of disciplinary and was disciplined for submitting fraudulent paperwork and stuff like that to courts and things like that. So let's keep that in mind. His character can't be trusted. Just should I put that in here? Robert Hutchins. And I know why she picked him as her fucking attorney, okay? Con artists and scammers and shit like that. They like to flock together, don't they? Anyhow, plaintiff alerted Columbus Urban League, Monica Womack, and Anjanette Leiter of the landlord and securing of contractual agreement, and as a legally binding lease agreement is required of Columbus Urban League prior to any funding disbursement as a condition of their own contract with grant funders, including stakeholders like Columbus Women's Foundation, United Way of Franklin County, Adam Board of Franklin County, Ohio, Community Shares of Ohio, okay? Okay, no funds would have been dispersed to defendant Yvonne Dyer if there was no meeting of the minds between both parties prior to phone conversation and interview. Defendant Yvonne Dyer participated in with Anjanette Leiter as a part of the verification process Columbus Urban League conducts. It's true. Defendant participated in Columbus Urban League verification process, inclusive validation of being the landlord illustrated on the lease first month and security deposit and monthly rental amount required of plaintiff prior to Columbus Urban League Accounting Department approval to release funds. And plaintiff received email confirmation post conclusion of the verification process. Defendant received funding payment from Columbus Urban League on June 15, 2021 in amount of $5,400. The lease contractual agreement began July 1, 2020. Defendant breached the contract due to her inability to uphold landlord obligation and duty under landlord tenant law, and that was illustrated in the bind in which was illustrated in the binding lease contractual agreement. Due to the inquiries related to the habitability and safety of the unit in which defendant had been paid by Columbus Urban League to secure safe and habitable housing for a plaintiff in need of housing crisis intervention, defendant became defensive and upset and breached the contract, knowing and understanding plaintiff had prepared for move in on July 1, 20. I keep typing that. In secure storage units, moving personnel and assistance, space eviction and homeless. Defendant constantly persistently made verbal modifications to the lease contractual agreement without mutual agreement of the plaintiff, post receipt of $5,400 from Columbus Urban League and continued to push the date out to July the 9th. Defendant provided keys to the plaintiff to move in at a prior meeting at the premises where she allowed plaintiff and her daughter to enter the home of the current tenant at the time, Amber Gilliam, without tenant permission. Plaintiff later learned in conversation with the tenant. Plaintiff intends to show via exhibit evidence and witness testimony of Columbus Urban League personnel, Anjanette Leiter, Monica Womack, VP, no longer employed with Columbus Urban League, Irene Scott, accounts payable, Columbus Urban League, and any alternate person identified as expert or on the witness disclosure list or in position to validate, substantiate, and or outline required elements necessary to prior disbursement of funds to a landlord in efforts to secure housing for individuals in housing crisis. No question exists on whether the lease contract existed, nor if it was binding or legal, as if it were not. Or if it's binding or legal, as if it were not, defendant would have never been paid $5,400 for Columbus Urban League in the first place. And this is known of defendant. Defendant noted in answer to Franklin County Municipal Court case 2021 CBF 022482 that she was not a landlord and did not own the parcel. She drafted the lease and entered into contractual agreement with plaintiff. Franklin County Municipal Court Judge Mark Hummer dismissed the case without prejudice following plaintiff discussion with the mediation officer regarding the case and prayer amount being sought exceeding just the judicial limit of the lower to your court. Therefore, as is reflected on the FCMC docket, the case was dismissed without prejudice and plaintiff refiled in his honorable court. Plaintiff is entitled to a jury trial and will file demand for a jury trial to ensure impartial individuals are at the forefront of justice. Defendant is opposed to jury trial due to the public scrutiny, especially given the overarching issue being housing, and this instance involves a housing crisis situation and a fair and impartial administration of justice. Plaintiff believes her rights are at risk of being deprived and demands a jury trial in this instance. There has been no settlement negotiations, as defendant counsel has ignored the demand for settlement on September 21 of 2022 and final demand for settlement on October 22 of 2022. Please be advised, plaintiff is not receiving notice of this court of hearing schedulings or deadlines to submit filings, pleas, or filings of defendant counsel, and has been put at risk of deprivation of liberty, civil, human, and constitutional right to have this case heard in a court of law and by a jury. It would seem feasible to any reasonable-minded person that if no notice is received, one would likely not appear at hearing schedule. Is there a technical issue with the ECF system? No service via U.S. mail has been received either of the most recent case activity. Plaintiff is now aware of post-receipt of email from defendant counsel to an incorrect email address that luckily belongs to plaintiff's daughter. Plaintiff requests this case to be conducted fairly as pro se. Plaintiff is disadvantaged, and the input of the community in this incident is critical. All right. And that was sent to him, Robert Hutchins. All right, you can look anything up you want on his ass too. Okay, let me see something. So anyhow, this is that damn lease. There's the address 17774 Bidewee, Park Place 4320 whatever. All right. Let's see what she's saying. Yep, supposed to commence on July 1st, 2021. Remember, she had already been paid $5,400 from Urban League. Let's see, she put in here that the rent was $1,450. Okay. All right, so she wanted me to pay the rent on before, blah, 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 at any key bank or such other place as the landlord may designate by making a deposit at key bank account number right here. Account number ending in this. All right, so we need to copy this over to something real quick because we want to make certain that that bank account is actually the bank account of her investment property that she's going to try to make it seem like she was actually renting under that. So we want to make sure that any monies that she's been receiving for the rental property that she has, I'm just gonna send an email to myself. All right. Yeah, we want to verify. Send that to myself real quick. I got so much shit I really need to clean out. All right. Oh, that's my one email. Let me go into this one. I should have sent over here because I sent from one of my emails over here. Okay. There that is. Because I need to verify something. I'm gonna go and check. I actually have a document that shows me the ending of her bank account. Yeah, so now let's get back over here. Okay. So blah, 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 blah. Okay. This was a security deposit. This was first month's rent. This was how much total, 5,400. Columbus Urban League helped me out with that, right? Because they thought she's getting ready to have somewhere stable to live. But have somewhere stable to live. Now, you know, there actually was something shady that came behind this later. Actually, So what happened was, this is just the truth. Okay, what happened was they sent this money to Yvonne Dyer. Um, Yvonne Dyer, she ended the lease on July the 8th. I was supposed to move in on the 9th. I really should have been moved in on the 1st. She already breached the contract by not letting me move in on the 1st, right? Well, after she breached the contract, she went on and sent the money back to Urban League, pretending to act like she didn't, just trying to backtrack and cover her own ass for getting in trouble, right? All right, so I outreached Monica Walmack, the vice president at Columbus Urban League, and everything, and told her the whole situation and all that. So she knew that I didn't have housing, all right? Monica Walmack did. And so what she did was she linked me to legal aid, and I had filed a fair housing complaint with the Columbus Urban League. I don't know what they did to investigate, but they never investigated anything at all with regard to this, with what Yvonne Dyer did, or with what Krishna Quadatata at 2951 Huffington Place did. They all had the awareness. So I filed fair housing complaint with Urban League too, and they really didn't do anything with that. But I'm not so mad at them. I mean, they tried to help with the money to get me somewhere, but Monica Walmack actually went and she used my name without my consent. So she violated my privacy. She literally took my situation, which is a pretty much embarrassing situation of being in the homeless population or whatever. She didn't have my informed consent to go and tell an actual journal about my situation. And she said my whole name. She said my whole name, and they printed it in their journal. They printed my whole name in the journal, and they said that Columbus Urban League had helped me secure housing, and they had paid $5,400 on my behalf. And now I was living in stable housing, but I actually wasn't. At the time that Monica Womack told that information to the journalist, she knew that I wasn't, and she knew what happened right here with Yvonne Dyer. And she knew that Yvonne Dyer had already sent the money back, and she knew that I was still in the housing crisis and I didn't have any help. But Monica Womack went out there. She was a vice president over there at Urban League. She went out into the universe and she told that man my full name, my life circumstance of hardship. And an embarrassing type of difficult situation. And I never gave her permission to do that. And she did. And they printed it in their magazine or something. But I have a sense of discernment. Things come to me. I'm alerted of any and everything that people are trying to do behind my back. And so I don't know why. You can go ask Jesus why. Go ask the guardian angels or whoever keeps guiding me and telling me, but I do get the awareness. So you keep fucking around if you want to. Yeah, because I get downloads of information. It's true. Something just told me to Google my name out the blue. It's a download. And I did. And that article came up. That's how I gained the awareness of what Monica Walmack did. So she was going behind the scenes to make the Columbus Urban League look good. That's what she did. She went out there and made it seem like, here's a testimony, or like, here's an actual example of what we did. We paid $5,400 for a girl to get in a place. And now because of what we did, because of what she's doing good, she's got a housing, she's stable. So the first part of it is true, they did pay, and they did try to do that. But it didn't pan out, that it fell through because Yvonne Dyer is a piece of shit. And she did send the money back to them and stuff like that to cover her ass. But at the time that Monica Womack went out there and falsely gave that information to that reporter, and she gave him my name and everything like that, you're not supposed to release people's names without their consent. That's my personal information. It's my first and last name. And she's telling my business. All right. And I don't want it out there, but she put it out there. So, and I was able to find it. And then I contacted that particular journal. It's actually an authoritative journal too. I contacted the reporter and I told him, and he was very shocked. And he said, I apologize. He's like, she's the one that told me that. She told me. I said, no, I said, it's a lot of mess behind that that did occur. I said, but at the time that she reported that to you, because you could see the date of the article and all that, I said, she knew that it had actually fallen through, that I don't have the money, that Urban League actually has that money back. I don't have it. And so he actually outreached and tried to call, but she was no longer working there at that particular moment. That this all came out. Yeah. And I told Urban League that what they needed to do was go ahead and pay this landlord where I'm living now, like $5,400. And they need to call that reporter and get my fucking name off that shit that's out there in the world. I didn't give no consent for that. That's violation of my privacy. You pay this landlord that, because that's what I had to fucking pay to move in here. I had to pay my own shit. Okay. Now Yvonne can give me that damn money. Okay. Yvonne needs to pay. She needs to pay for my harms and everything that she fucking calls me. Yes, she does. She breached the fucking lease and she wanted to get out of it. She's a piece of shit. So anyhow, I called Urban League. I said, y'all can give it to this landlord. I'm in the hard, I'm trying to dig out of a hole in a whole hardship, even moving in here. I started that job at CVS and I was already going through shit. So, I mean, damn, I'm trying to do the very best I can, get up every day, go to work, do the best I can to serve my patients and everything like that. I did everything I was supposed to do. And for them to fire me and do all that behind me just asking questions, that's what people get mad about. You ask questions and stuff. You want to do the right thing for the right reason. You're trying to do your best job so you don't hurt nobody and stuff like that. And no, bitch, I'm not adding nothing in nobody's chart that don't belong. I'm not going to say something that somebody did something they really didn't do. I'm not going to delete nothing on nobody's chart. I'm not going to put my nursing license on the line for you to where I can be held accountable for something at the end of the day later on. And say, oh, but she told me to do it. And she's like, I'm not going to do that because I'm bringing all this to the attention of all these people that they tell you to bring attention to. They get rid of me. Mm-mm. And I was willing to accept that, just say, okay, well, let's settle on the EEOC and just whatever. I mean, it's wrong and everything like that. But, no, it's not okay. And then you don't want to pay me my $15,028 at the Resource LLC, CVS Health, Alex Frondor, Richard Diabio, Karen Gaster, and whoever the fucking EEOC. You don't want to come and have my back. You know everything's been breached. You know I've been wrong. You know it's a whole crime involved and shit like that. Okay, so who's going to hold all these people accountable? There isn't anybody who's going to. It's all lies. Okay, so they don't give no fucks. And too bad for you if you're Black. I guess. I don't know what it is. I don't know what their reasoning is. I mean, that's the only thing I can think of. Like, I mean, what? It's really strange. Yeah. So, it's all true. Okay. The shit is still fucked up out here. I went on Columbus Urban League site and looked to see what they're doing with that rental assistance shit. They still having people show how COVID affected them. Why hasn't somebody went in and revamped that shit? That is part of the quality improvement plan too. You have to look at your current processes and you have to go back and see what's effective and what's not effective. And where modifications, updates, revisions, or whatever are necessary and needed, you have to implement them. What the fuck is that shit about COVID still on there? That's not why people are having issues right now with the rent, because of you have to demonstrate how you was affected with COVID. Get that shit off of there. That's the bullshit. That's what they have on there so people can't demonstrate it so they don't have to get the money. Okay. It's all fraud. It's all scams. It's bullshit. Well, not all of it, some. This one I'm talking about is not everybody. It's just some. And I'm not really wanting to dog Columbus Urban League, to be honest. I really do like Columbus Urban League a lot. So I'm just telling you truthfully what happened. And also, it's not, again, the entity itself. It's not Columbus Urban League that went out there and told me my name without consent. That was Monica Womack as a vice president to make herself look good. And like vice president, and let me do, and get everybody thinking. So then maybe that she could use that when she went before the stakeholders and funders on the next go round for proposals. Say, yeah, and we actually were able to get housing stabilization for this lady right here. And this and knowing it wasn't true. And I didn't give you my name. I didn't say you're to be out here giving my name to motherfuckers and stuff like that. And I didn't sign nothing that said that if we pay this for you, it gives us the right to utilize your name and anything about your private situation. But they did that. She did. And she doesn't work there anymore. But I'm going to actually find out where she's located so she can subpoena into court and she could talk about this. I'm not going to bring up that. We can talk about this. Okay. But yeah, that's just the background on that shit. Just show you how shady motherfuckers are. But I try to tell people to really leave me alone because I actually am guided by something. I don't know what. I say it all the time. I don't know what, but somebody is guiding me and they give me information. I would have never known that about her saying that. Somebody told me in the message. It's a download. I get them all the time. Now, also, what else is she saying? This let's see. All right, let's see if we find some of the freaky deep shit she's putting in here. Some of it is just standard. Let's see. Yeah, so you're responsible for having your own property. What's the name? Um, Insurance, as like tenant insurance and stuff. But she already knows there's issues with the place. Found out later from the tenant. She knows septic tank doo-doo and all that stuff comes up from the bottom and pee and whatever goes down the toilet, comes back up to the basement, it's gonna fuck this shit up. She already knows this. She already knows it. She's just not handling it. Then she wants you to pay half of the shit. I said, let's find some of the shit in here that she got. This is public. You can watch this case. Right? It hasn't been set for the hearing yet. So you go ahead and watch it. Franklin County Court of Common Pleas, 22 CB 003339. Law students, all these cases is good for you to learn off of, honey. So you learn what the fuck not to do, baby. Okay. All right. So she was saying that all this was due July 1st. Oh, that's just, oh no. Okay. So she already knows there's plumbing stoppages and all that, but I didn't know that yet. The tenant just told me later when I got to, she already knew this stuff. She knows her shit, plumbing, bus, all that shit, bus. She already knows. She already knows the dookie and piss and everything comes up. She already knows, but she's going to make sure she got in her contract that it goes over to you. She already knows the problem exists. And then also she said, tenant agrees to split the $150 warranty deductible 50-50. So she wanted me to pay for the thing. You really shouldn't be putting stuff like that in there, paying on your. It's like, yeah, I'm looking at home insurance on there, and that tenant told me she like, girl, she got home insurance. She been at Amazon. She happy, and it's only $75. That's what the tenant told me. It's only $75. Anyways, so she's trying to get me to pay my part so she can pocket the rest. See, she's a scammer. She's a con artist. But people in our family already talk about that family unit within our family as being a family unit of cons. They never told me that she was. It's mainly her sister. We talk about her sister. Her sister frauds insurance and stuff like that all the time. She's burned down her own house and got insurance money. She cut off her own toes some type of way and got money. She's like in a wheelchair and stuff like that. She on the back of her license plate, it says something like "sue for you." That's what she does for a living. She sues people. So this, she acted like her son's arm was broke or something like that. Had him wearing a cast, act like he fell down, broke his arm and shit like that. And got money. That's what family members say. I don't know for sure. That's just what they say. And she's part of that family. So it's not really no telling what type of fraud and scams is really going on. But damn. Yeah. I mean, I don't know if this is what people are saying in our family. We are actually family. We are blood family. Yeah. Yeah. So her mother is, I think her mother is my grandmother's sister. Yeah, something like that. And she's my cousin. She's my mother's first cousin, my second cousin. It's really sad, because I never had no issue with her ever. Like I loved her to death. Like, oh, this type of shit doesn't make no sense. Now, I don't consider her to be family. Family doesn't do this. I don't like her at all. At all. At all. Period. And it'll take me some time in dealing and talking to the Lord to ever forgive her for this. She's a low down dirty dog. She's a demon. So, what else? Okay. So there's nothing about Korg Investments on this document at all. It's just Yvonne Dyer, her address, her phone number, It doesn't matter about none of this information. It's public fucking record. Okay. Okay. This is what she signed as Yvonne Dyer, not Yvonne Dyer agent, not Yvonne Dyer agent for Korg, not Korg Investment, not none of that. This is her individually. individually, Yvonne Dyer, individual. This is signed, everything, okay? This is legally binding, yes, it is. Okay, so let's see if we can find her email. All right. All right. Here we go. This is from Yvonne Dyer. She said, April, as an experienced landlord. She told Franklin County Municipal Court she's not a landlord. As an experienced landlord, I'm a experienced Caesar French fry landlord. I understand how important the landlord-tenant dynamics are to a win-win rental experience. She just outside of her neck. Because of this understanding, and after consulting with the Urban League and Legal Counsel, I'm formally terminating our lease agreement before move-in. You see that? I'm formally terminating our lease agreement before moving. But she's trying to say, right? She's trying to say there was no binding lease agreement, there was no meeting of the minds. There's a lease agreement, right? So the date that she sent this was July the 8th, 2021. Okay. As I said earlier this week about the walkthrough, I would do all I could in good faith to meet your expectations, but if I couldn't, I would end the agreement and return a deposit to Urban League. The past few days of continuously intense email exchanges and pre-move-in concerns have led to decisions to end things now because you had an urgent need to find a place. I did the best I could to provide a solution. However, the experience thus far has indicated that I'm not the right landlord fit to do. Yeah, so. I got a lot of stuff in here. That's some dirty lines. Look at that. She refused to take them down. Yeah, she said she ain't gonna take them down. You could take them down because she said that girl don't smoke. But when she let me in her house and her property, it was nothing but a whole bunch of cigarettes in the damn ashtray. And who cares? I mean, she can do whatever she want to do. She can smoke in her house or whatever. And if she don't smoke, that's okay. Somebody does. This from Yvonne Dyer. She would bother me when I was on my job, CVS. She was bothering me. I just can't drop everything and do whatever you want me to do when I'm at work. I said, you know, I have obligations too, and I cannot modify. And it is rather selfish of you to have such an expectation. I'm shocked. I said, I had movers prepared, trucks scheduled, and a number of prior move-in preparations that now need modified as the property was not move-in ready. All right. I am not available today, and my availability tomorrow has been aforementioned. What Nate can do is leave the key and I'll do a walkthrough video and document any concern issue. I will complete the document you sent post contract as well. He does not need to be present. Okay, so let's do this real quick. Let's do this real quick because I did tell what's his name? Her attorney. Since he set up here and lied, he can go ahead and give me a call. He's going to talk about settlement. If you're going to play it in the damn court. Might already have one in there like that. All right. Let's see what else. Is that the same one? Okay. So let's read this to you, then we'll say it. Then you modified the contract without discussion with the move-in date of the 9th, and I compromised without fuss, given the courtesy air conditioners and dehumidifier with no upfront discussion on a walkthrough date occurred. I cannot revolve my life around when you or Nate are available. I have obligations too. Oh, is that where it started? Yeah, that's where it started. I got obligations too, right? You just can't tell me call off from work and I need to do this, that, and the other. I think I printed that whole thing. What else is down here? I cannot just sit up and jump up when you say, and I do not operate in that fashion ever, okay? I cannot make any adjustments to my scheduled appointment for today. The contract is for the first. Then it was hopefully after the second. Then yes, the fifth should be fine. Then, oh, I made a mistake. Then I can return money to Urban League and break a legal binding contract. Then you modify the contract without discussion with the move-in date of the night. And I compromise without, yep, so there it is, okay? And that's why she's pissed. So then I told her I'm logging into work now and will be unavailable. As I stated, I'm unavailable today and your notice is short. You expect me to drop what I'm doing to accommodate you and or Nate, not cool at all. I cannot, there's a whole shit. Or I cannot just sit up and jump. Yeah, right, exactly though. This is her. Good morning, April. I know you work during the day, but what time this evening can you do a walkthrough? I have a scheduled obligation, which I did. That's a little bit of a problem. Nate's going out of town tomorrow, and I told you could move in on the 9th. I told you could move in on the 9th. I'm going to send this. Let's just send this to her attorney real quick. Let's just do this. Let's do it. What I want to do. Okay. Let's send that to you. All right. Okay. So this is evidence. I have all the evidence, right? So I have the lease contract. She's acting like it never did exist. I have witnesses. I've already put my witness disclosure list and everything like that. I can call everybody in about there. Legal contract did exist. Okay. Yvonne said that's the I told you you could move in April the 9th. The contract says the first, right? So I mean she's playing around. She's like, that's not good. Yep. So let's see what else. Oh, that's a nasty blonde. Let's see if there's anything else. This was the fair housing thing. This was the person, Associate Vice President Monica Womack with Columbus Urban League. We received your complaint, are coordinating with the proper organizations. Okay, so basically, I guess the only thing that they really could do was link me with legal aid at the time. So I did get free consultation with that. Yeah, she's saying she ain't a landlord. She rents property, accepts funding from tenants and governmental agencies, and she claims she ain't no landlord and owner and all that type of shit. Yeah. Sorry if I'm messing with your eyeballs. What else can we find? What else can we find? This is a whole different cat. What do we talk about on here? Oh, we started talking about something else. But yeah, this just goes to show you all of the wrongdoing that goes on. That's pretty recent. Let's see what else. Oh yeah, like I really need to clean this shit out, don't I? These are interrogatories I wrote for her, and they half-ass be wanting to answer the shit and all that, they be half-ass wanting. See, motherfuckers think I'm stupid. I'm not dumb at all. I'm not dumb, boo. I ain't no lawyer, but I ain't no dummy. Okay? All right, so let's do this real quick. This is what you have to do. This is what you can do if you're pro se and fighting for yourself and stuff like that. Let's see. Let's go to here. Did I finish reading this? Let me make sure. Yeah, I did. I think I updated the address on everything and also those dates 2021, 2021. All right. So, yeah, so basically, oh, let's go back here. Let's go and I'm going to go ahead and e-file this real quick. The amended. Then I just have to remember that tomorrow I need to, these are all my cases. This one right here, this is Christian Quadatata and All County Neo 22CV003620. This is deprivation of rights case. Under color of law, Karen Phipps. Yeah, that's what she did. She, oops, I don't want to file to that. She, yeah, revoked the tenant's rights. Yeah, she should be in jail. She committed a crime. That's what she did. Yeah, she denied all my shit. She just doing shit on purpose, boo. Yeah, we had all kinds of shit. That's the least. That's the least. All County Neo wasn't even on this lease. It was somebody named this guy right here. That's his cousin, brother, friend. He didn't get property management until we actually paid him the entire lease. Then he got property management. It's the same thing. Yeah. Let's just pick something random. I think I've showed all this shit. Yeah. Oh wow, here's the water heater thing, right? This is where I actually sent to the city September the 21st of 2020 to 311.gov. The flames from the water heater presented a safe hazard for the property. Basically, this was my daughter saying, listen, we need a property inspection. It's unsafe. You know, the water heater throwing out flames due to the buildup of dirt. And the gas company had a red flag, and property management landlord had disregarded the emergent nature of the need for that. Please help. You know, like, so we were always constantly reaching out to the city for help. We could have died. We could have died. We could have blew up like those people did. But the city didn't give no fucks, right? Here go another one. We said, hello, requesting a inspection. That's wrong. Yeah. 2951, right? That was Tyrone. Please accept this notice. Found over the city, my family has been experiencing headaches and nausea, which may be attributed to the mold growth and rotting floor. You were notified of that move-in over 30 days ago. This was to him. Okay. A motion for escrow filing will be drafted and submitted prior to close of the week. In the event you secure licensed personnel to address leaks and replace and treat molded flooring adequately, please advise me within 24 hours. This matter is urgent, because he said, like, calling him about small things and shit like that. That's what he was saying. Like, that's not small. Like, I mean, I don't know what you're talking about. Look, I got off track, honey. Oh, that's the one. It doesn't matter. Let's see if we can find, let's see, pick a mystery. You said that. Okay. Yeah, this is one of the public records that's at the city of Columbus. Remember, I told you there's over 29. This is what they'll look like when you ask them for your what's name. Yep, so I'll be telling everything. I'll tell it, yeah, what I was saying in here. Yeah, I said something about yeah, I put in here. I had like yeah, Todd Diller, have Tia Ross, and she has done, what has she done to date? The family will be homeless due to exercising tenant right to complain to governmental agency like yours. You are aware and have ignored what is Tierra Ross doing with the retaliation paperwork. Why is Christopher Clark acting as if an inspection has not already been done? A re-inspect was done to the owner of property management have fixed nothing deliberately. They are con artists, scammers, and your entity is aware, but don't want the public to know how you sweep under the rug slumlord acts in this city. Okay, I'm not fucking playing with these people. Yeah, the code case EVH 0600439 is due to tenant complaint of violations during tenant stay who still reside at the property. Property management filed eviction and placed tenant under duress. As you well know, the attorney Michael Casone threatened to have the tenant set out immediately if they did not retract the true report of fraud to the landlord home insurance for his admitted false incident claim submissions, and text the tenant to lie about pre-existing issues at the property, which are going to, what are you going to do about this? Because the tenant complained retaliation occurred. This is illegal, and Tierra Ross has a retaliation paperwork to just chew on it. Okay, shit. Hell yeah. And then what they say, no cause for action. Yeah. So this is what they said. They said that's how the housing violations that were cited have been referred to Franklin County Environmental Code. Please see where they don't do shit. Okay, I'm telling you. Yeah, this is 22 CB 003620. Karen Phipps, she had that in front of her. She said she briefed the entire case, but she found a harsh judgment for her buddy Pal, so didn't she? See, is she a liar? Shouldn't she be in jail? She should be in jail, tying a t-shirt and a halter top, trying to figure out how to make them damn grilled cheeses and shit like that with the iron. You already know. Yeah, so what's this? Oh, there go Michael Casone's, what's the name? His review for All County NIA. This is his review, Google review on their webpage. He's just basically saying that, Rob, that under there's Rob and his team at All County NIA run a tight ship and do an excellent job in managing their properties and taking care of their clients. I don't see that. I would recommend him to any owner that was in need of a property manager, because he's the owner that they manage his properties for. Yeah, Michael Casone, Michael, what's up, bro? Piece of shit. You already know. All right, so this is just all the shit that was on that damn case. That's a lot. She couldn't have totally briefed the case, of course, right? All right, so this is just some guy from All County NIA. He accidentally sent a text to my daughter. Thought he was sending it to somebody at All County NIA, calling my daughter this nuts. This lady's nuts. Yeah. So this is basically where we said, about the garbage disposal, blah, blah, blah. He was saying, hey, remember he actually, he don't know English. This is him typing, saying, maybe. So we can tell that you might have an issue right here, because that's supposed to be MAYBE, but maybe they have but he knows exactly what he's doing. Maybe they have a signed different person, signed meaning assigned, okay, right? Different person for that job, but don't tell him. He's fake and he's a liar. Don't tell him, because if we can get him to fix both, then that's great. We don't want to pay another $65. We got to pay for every visit. Like, these are con artists, okay? All right. So this is what I was talking about. This was all my towels and blankets and stuff like that, cleaning up all these leaks and load and all this shit. Okay, so I tell him, like, somebody needs to come, a professional person, look at this. He's like, okay, thank you. They will come and take a look. Just remember, the leaking should not be continuous for a long time and mold. If you tell them there's mold, insurance policy doesn't cover the mold. I put the incident date as August the 7th. That was a lie. Just tell them you noticed the leak on that day. That hurts me a lot. I'll do that, but Karen Phipps had all this shit in front of her, and the bitch, you see what the bitch did? Yeah, so anyhow, we done with that shit. So I need to be investigating her, but we know how that go. Yeah, here go Yvonne Dyer. This is what we're getting ready to file. We're gonna put the amended thing in here, so we got the right address.